61 IL correction of order.
21.
Next Tuesday.
Tuesday. Next Monday. Maybe but tomorrow a matter has listed that I attempt of 20. I have filed an IA for a withdrawal of one of the petitioners. That may be listed enough. IA has already been filed.
My lord, I beg to mention one writ petition of 21. It is relating to retirement benefit of Hotel Brahmaputra. And on 10th of May, it was listed but not reached. Any date may be given next week, my
Next week, not be possible. Please. Okay, we'll have it try on 16th.
16th. Well,
Next Friday.
With your lordship, I beg to mention WC 278 for listing in a third week of this month.
When?
Third week of this month.
Third week of?
This month.
Matter of which year?
Land acquisition.
Which year?
Last year.
2022. Land acquisition. Okay, we'll have it on this third week of this month.
Third week.
May please your lordship. Lordship, I beg to mention one writ petition for listing. The matter is relating to transfer lordship and there is stay order.
Here for the respondent.
I am appearing for respondent on behalf of Mr. S.K. Medicisi.
When do you want?
16th of June.
Have you filed any IA for modification?
No.
You filed affidavit in the case.
Yes, sir.
Okay, 16th.
May please a mention for urgent listing for tomorrow, man. What has happened? The petitioner.
Motion.
Man.
What is the matter?
My matter is that the petitioner is presently working as a director of forensic lab. What has happened without any notice and without any intimation, she has been transferred and she has been replaced by respondent number 4, who is an IPS officer and who does not have the desired qualifications by Rule 12 of the Rule Matter. And by law, the date of joining is by tomorrow. Tomorrow.
Okay.
Month. May I please the Lordship? Lordship, due to some unavoidable problem, my senior had to go back to his home. So my lord,
Which item?
Clear that item 23 of today's list may be taken up anytime in the second half. He has also informed the other side.
23. Your with Mr. Bunik.
My lord, I'm APM for.
Okay, but try to have it in the second half. But the other side has been informed, Mr. Das.
Mr.
SK Das is there.
Yeah, he has been.
Okay.
Your lordship, with the consent of the other side, I beg to mention item number 15, 18, and 20, lord.
15?
18 and 20.
Yes.
The R. Mojumdar is out of this, lord.
But 15 is of 2011.
Lordship will be backed by 12 of
Other side, as an exceptional circumstance, do not think that by giving a slip will allow mentioning. This is an 11 matter. Should make alternative arrangement. When is he back? When will he be back?
any day after 12. Lord.
When? After 12?
Yes, 12 of.
Okay, we will have this on 13th.
Okay.
13th. It is submitted that Sri R. Muzumdar, the concept for the petitioner, is out of station. However, issue of it's not the list on 13th of no, however, considering that this matter is pending since the year 2011, list on 13th of June. It would save 18 already, considering 16. Third 16 or 16 third okay, after list after 2 weeks. Are these matters similar?
No.
24 2 weeks. 15 or 18 almost like 11 or 10. Yes. 11, 15 and 18, 11 Tuesday. Whole matter. 20 after 2 weeks. Yes.
May I please, Your Lordship, for listing Lordship, in WPC 1370 2000, we have filed the IA Lordship.
I have for
IA for the respondent must be violating the order Lordship. For that, sir, we have filed the IA.
you for the petitioner.
And for the,
When did you file the IA?
on 5th Lordship.
When do you want the IA to be petitioned?
Lordship, next week, any day.
We'll have it on 19th.
19th.
On 9th.
Obliged Lordship.
May I please, Your Lordship? Lordship, in item number 20, my senior Mr. Estimate is for the respondent.
We have
In-
already mentioned this matter. 2 weeks.
Item
13 will be difficult. 20.
in 30th June, my senior will be out of session.
We are not fixing this on 13. 20 is after 2 weeks.
Two.
Only 15 and 18 is on 13.
Obliged, Lord.
In this series of cases, we have challenged the B.Ed degree offered by mainly two institutions. One is Dr. Prosecution and another is Vivekananda College. And in both the cases, my lord, the NCT has filed their affidavit and stating that the degrees which they were put to challenge are not legally valid.
Why has this matter come before this court?
Lordship, in fact, Lordship, on the same issue, Lordship was already heard 1 week back, Lordship, in case of Mukherjee.
No, that is
Same
okay,
issue
but
will
today
come-
we are bench free.
Lordship.
Today we are bench free.
That is okay.
Tomorrow I can take up. Tomorrow again, I think we'll be bench. Today we cannot.
But Lordship has already fixed that. Other cases, Lordship has 12. So Lordship will fix these cases on 12.
Okay.
Yeah, same issue, same.
It is submitted that the issue raised in this batch of writ petitions are connected to an issue in certain other writ petitions which are fixed on 12th of June 2023. Sarah, list these cases along with
WPC 5221.
those cases. The lead case being WPC
5221 of 2022 Mukherjee.
522 2022 on 12th of June.
Lordship, 5221 2000. The petitioner name is Musabir Ali.
Doesn't matter. 5221 of
2020.
2022.
The issue is slightly different. Here, Lordship, the
Let us
petitioner
have it on 12th. Today we are not discussing bench 2 matter.
Obliged.
Before your Lordship, the master of finance.
Bench 2. Not today. Let's be for appropriate bench. We'll go by the listing and the rotation.
item 8, my lord.
Which item? Yes.
Hello.
Pathak, you are appearing.
Hello.
Yes, yes. What is this?
This is, my lord, against the transfer order. The petitioner, my lord, he is a specialist doctor in dermatology. He's serving in the SSB, my lord, and on 17/5/2023.
Who's for the other side?
from the
CCC.
Central Government Council, my
Huh? CCC. Mr. Mehdi? Who is the Who's the
We generally service the AG's office.
who is appearing?
I don't know, somebody is, maybe I'll take information.
Try to get the information that whoever is interested, let him talk.
My lord,
Before-
my lord. Let me
Can-
find out.
You can place the fact.
My lord. So, my lord,
Where is the order of transfer?
my lord, annexed 3, my lord.
Page
Detail 26, my lord. Serial 14.
17.5.
Serial 14, my lord.
17.5.
75.
Serial number 14.
Serial number 14, my lord, Dr. Nazir Ahmed Shah. He has been moved to, my lord, from Tezpur to Salonibari. Tezpur Salonibari to Rupa, Chairman. The transfer came within 11 months of his posting at this. And that apart, my lord,
Is there any policy?
yes, my lord, there is a policy which requires that specialist doctors, my lord, posted and, my lord, their transfer has to be considered by a committee.
No, is there a policy regarding the minimum
Minimum
tenure?
tenure is, my lord, 3 plus extendable by 1 plus 1.
Normally,
1 plus 1.
normally.
Normal tenure is 3. It can be extended by 1 plus 1. But then in cases of urgency, of course, he can be moved.
And
But
this, you say that there has to be a committee
there is a committee,
for a
my lord.
specialist.
My lord. And in fact, there are other cases where the same policy is not considered. No adherence to that policy resulted in free of
Let us
transfer.
see that policy.
Annexure 2, my lord, page 19.
Yes. Where is it?
My lord, this is for, my lord,
It's got nothing to do with transfer.
my lord, this is relating to qualification, my lord. The transfer policy, my lord, is,
Mr. Pathak, you prepare your brief with the court.
my lord, today there was some difficulty.
Monday.
My lord. The annexure, my lord, 9.
Sorry.
Annexure 9. Annexure 9.
Not from you. Monday. It appears that the council is not prepared with it.
Annexure 9, my lord.
Please on Monday.
But there are other orders to that extent also, my lord. The same policy, my lord, in other departments. Annexure 11, lord, it is considered.
We'll consider if you assist the court.
My
Not
lord.
when you turn over pages in the court from page 1 to page 20 to look for a policy. And you take a policy of pursuing MBBS and MD. Monday.
My lord,
Sorry.
Friday, tomorrow.
Tomorrow, okay. Next. Motion matter, Mr. Pathak.
My lord, I
Minimum time you should take.
I arrived just this morning. My
That is
lord.
not an excuse.
And
Then you don't move. Ask your colleague to move.
Right.
Yes, next. Ready? Mr. Rajputta, what is this?
So actually, espousing the cause of the contract laborer who were working in ONGC establishment.
And the second matter,
Same that
issue is the same. Second is by some individual. And the first is by the association.
Well,
Union.
they are also members of this association.
Union. Perhaps these members, they do not trust the union. They say, it is delayed in the first matter. Therefore, separately they have filed.
actually
So we have
they,
taken a
they are
ground
they are
matter.
defected
Rest
members.
of
My
this
lord.
matter.
They were our members. Subsequently, they
Then 2022 matter will hear it at 2028. 16 matter will hear it today. Okay. Where are you argue for a final disposal?
yes, sir. Or your lordship make a fix the date
No, we are taking a 16 matter. We can take it up to Thursday, hearing matter. Just take. It's Savala.
Yes, my lord. Can be taken up, my lord.
Any working Thursday or Tuesday?
No, today. Today we are taking.
Today.
No, if you have some difficulty, there is no
No,
problem.
I don't have any.
No, Thursdays are meant for hearing with 16 matter.
No, Lord, what happened in this case? Let me put the fact in brief. In the year 2009,
Just let me two matter. Yes, please.
in the year 2009, Miller, an industrial dispute was espoused by this union.
By the union.
This union itself. So in that dispute, the basic terms of the reference was for the fixation of the minimum wages to be paid to the contract workers who are working in the ONGC establishment. Just as the wage. That dispute was referred to the central government industrial tribunal, and dispute was proceeding. So in the meantime, Milord, what happened in the Gujarat, there was a settlement between the ONGC and the local union. In that settlement, some fair wages policy was formulated. One of these policy was that the contract laborers, so far the contract laborers are concerned, they will remain same, but the contractor may be changed from time to time. Now, in terms of that settlement, Lord, throughout India, this fair wage policy was implemented. And the award was passed. And that in that award, there was a cut-off date. The cut-off date was 1/4/2012. The person concerned who were working as on 1/4/2012, they will get the benefit. And the person concerned who were not working on that day, they will not get the benefit. So we don't have any other option but to abide by that. That thereafter a settlement was arrived at, and award was, I will refer this award was passed. Now, during the pendency of this award, Lord, we have filed an application under Section 33A to the effect that so for the other workers that are concerned, their condition of service should not be changed. Should not be changed.
Yes.
Changed under Section 33A. Now,
Okay.
as this award was passed, Lord, so we have to withdraw that application under Section 33A, and we can leave to educate this matter in the appropriate forum. and this settlement was for a period of 5 years. 5 years. That period has been expired. Now, below our endeavor before your lordship would be that the person concerned who were working as a contract laborer, they will also be given the job as and when the contractors are engaged. That is our sole object before your lordship.
You said that settlement was for 5 years.
That was settlement for 5 years.
That means, though a cutoff date was fixed as 1/4/2012, the persons who were engaged as contract laborers prior to that date will remain in the ONGC irrespective of change in the contract.
Yes.
Now you want that this settlement, which was for 5 years, to be extended. That is your plan.
Now, my lord, our basic endeavor before your lordship is that the person concerned who had worked prior to
But under 18,
no,
isn't it
prior,
binding before you?
no, prior to 2012, the person concerned who were employed as a contract laborer, but they were not in the working as a contract laborer in the year 2012. Yeah, below, they may also be taken into account when new contractors are engaged.
So it depends whether there is some need of so many laborers. You may have, suppose, 100 laborers who are working as contract laborers.
So my
Suppose you may have, there may be a case where there are 100 laborers who are working in this as contract laborers. Now there is a need for 50 laborers in a particular work. Can you say that the other 50 are also required to be inducted or given work?
no.
The what the safeguard is that other people should not be inducted when you are there as contract laborer. Now, can you say that for a work which doesn't even require your service, so many laborers should be inducted only because you had worked?
No, that I cannot say, my lord.
Then
Only my endeavor before your lord, my endeavor would be that when some contract laborers will be engaged in that establishment, their case may also be considered. Because as per this fair-wage
so
settlement,
their cases will be considered subject to their need. If there is a need, their case will be considered. If there is no need, why should there? Where is the question of considering this?
now, my lord, section 25(8) of the Industrial Disputes Act.
IT expert, industrial, 947. Yes, please. 24.
That is re-employment of retained workmen.
25(8).
Fair, isn't it?
Yes.
Now it says where any workmen are retained and the employer proposes to take into his employ any person, he shall in such manner as may be prescribed give an opportunity to the retained workmen who are citizens of India to offer themselves for re-employment. And such retained workmen who offer themselves for re-employment shall have preference over the other person. So my contention before your lordship, Lord, these people who are working in the establishment ONGC as a contract labor, but they were retained prior to 2012. As they were retained, they could not be taken. consideration to cover through this firing. Very strict. So be that as it may, what has happened. At least we could protect 207 workers, but we could not protect other workers. Now we are taking the recourse of this section 25(8). Now look, now your lordship come to this defending
How many members are there in the union?
now at one point of time there were 1,500 workers.
1,500.
1,500 workers.
Contract labor.
Now most of them about more than 50% or 60% workers has attained more than 60 years of age.
Now about 700 are there in the.
About 300 to 400 more. My inspection is not over are there.
There are 300 to 400
Or it may be 500.
500 contract laborers whose services were discontinued prior to the cutoff date.
Yes.
And for them, you are espousing this writ petition. So that in any future work of the UNGC, if there is a requirement for contract laborer, they should be given preference under 25(8).
So
I don't-
in this case, there is an order to that effect. That order, you'll also will find this order, but you are not benefited by that order.
Mr. Sayola, what do you say? We'll come back.
My lord,
If
your
this,
lordship may see.
if this is the projection,
Huh.
what we are intending, it may not even cause prejudice to you. See, you are the principal employer. You have works done through contractor. They want that whenever the contractor comes, whoever, they should be given preference if laborers are to be engaged. For that, I don't think you'll have any objection.
Your lordship may just see what is the settlement and what they want now. My lord, your lordship may come to.
No, if you are not, we just wanted to have your response. We'll come to you.
No,
On merits, we'll come to you. Let him finish this.
Let.
Yes.
In fact, Lord, this court has an occasion to pass such an order to the effect that if they are to consider their case, and we approve before them, but no fruitful result has come out. So, my lord, I would like to have some positive direction so that we may be benefited. Now,
So what
Lordship,
was the consideration under 25(8) made?
yes, Lord, this where local law could also pass an
No,
order
not
in
by
that
this court,
effect,
not by
in
this
that
court,
effect.
not by this court.
Not by this.
In terms of the section, you say that some orders were passed by this court.
No,
No orders were passed.
no order, sir. But local law, once this matter was posted before the local law, and the local law order will discuss. Pujar Guru has made some observation, all that you approved before them, and submit a representation.
No, that is a local adalat.
That's
Was
a
there
local.
was there any court's order?
No, that was not supposed.
See, when the statute itself prescribes that your case may be considered, we cannot say more than that.
Okay.
You are retrenched employees prior to the cutoff date. You should be given preference to a new contractor, a new laborer. That is your prayer in consonance with 25(h).
25(8). And now look, this 25(8)
Yes.
is also applicable to the contract laborers. Now, prior to that, your lordship may come to the definition of the employer. In the industrial dispute itself, section 2G.
Yes.
Then I shall go to the entire matter. Just pointing out some provisions of law first. The employer
Yes.
employer means in relation to an industry carried on by or under the authority of any department of the central government or a state government, the authority prescribed in this behalf or where no authority is prescribed, the head of the department. But there is the employer. Now, if your lordship goes to the provisions of the contract labor regulations and regulations act, this employer has been defined.
1978.
Yes, 1970.
Contract. Regulation.
That is, of course, principal employer. Section 2G, same section, principal employer. But we are, our grievances will be against the principal employer. Principal employer means in paragraph,
Yes.
in relation to an office or department of the government or the local authority, the head of that office or department or such other officers as the government or the local authority as the case may be specified in this behalf.
2G you have read.
More or less same.
Yes.
The employers and the principal employers are concerned. Now, below, my endeavor before your lordship would be that these people, these persons who were working prior to 2012, their condition of service, that something may be given to them so that they may be employed somewhere. The way of going. Now, my lord, if your lordship come to the award, the terms of the award, your lordship will find the award itself an exact page. The award is an exact page 38. 39, start from 39. Merit.
What is the date?
The terms of reference, your
What is the
lordship
date of the
find at
award?
page 40.
Date of the award?
Date of the award.
Yes.
For September 2014.
Now is it 25 or 20?
25/9/2014.
Why this code has come in?
254 years. 25/9/2014. Now, this award was passed in terms of a settlement, and that settlement was for a period of 5 years.
Let us see.
Now, your lordship may kindly consider the terms of the reference. The terms of the reference will be found, your lordship, at page 40. Whether the action of the management of ONGC Limited, Assam Asset Najira, and ONGC Assam Asset Arkan Basin, Jorhat, in denying to concede to the demand of the union to enhance, increase, revise prevalent rate of minimum wages relating to the contractual workers under them as on that is very important, as on 1/11/2008, at least at part the unit of ONGC Limited in India, including Eastern region, or at least at part the prevalent rate of wages of the contiguous oil industry like OIL, Oil India, NRL, etc., situated in the state of Assam is justified. What rate of wages should be logical and rational, and the contractual workers raise this dispute are entitled to. Now, let me read some paragraph so that you can understand the facts of the case. On receipt of the order of the Ministry of, let us keep it up, paragraph 2. Paragraph 3. The case of the union, in short, is that more than 1,500 contract laborers were working in Shivsagar, Geleki, Lakua, Najida, Rudoshagar, within the district of Shivsagar. And apart from these zones, the contract laborers were working in the areas of Jorhat, Orgola, Torupathar, known as Assam, and Assam Arakan Basin of ONGC Limited. The same contract laborers were engaged in non-perennial jobs as per the policy of the ONGC Limited. But in fact, these laborers are engaged in all kinds of perennial jobs of the ONGC, and they have been working for a period of 10 to 12 years. And 95% of these workers were paid at the rate of rupees 1,500 per month. As per Section 21 of the Contract Labor Regulation Abolition Act 1970, every principal employer shall nominate their representative to be present at the time of disbursement of wages by the contractor, and the state representative are to certify the amounts paid as wages. While this procedure has not been followed by the management, the union persistently demanding for the proper disbursement of the minimum wages, fair wages, and the other basic amenities. That is very much important. Other basic amenities as required under the Contract Labor Regulation and Abolition Act 1970. But the management did not pay any heed to it. Thereafter, the union approached the Honorable Minister of Petroleum and Natural Gas, New Delhi, and submitted memorandum, but nothing has been done. The union submitted that the contract laborers of ONGC working other places of India are getting higher rate of wages than that being paid to the present workers. They cited the example that in Mumbai, the rate of monthly wages payable to the unskilled, semi-skilled, and skilled workers are at the rate of rupees 5,394 rupees, 5,519 and 5,664 for unskilled, semi-skilled, and workers respectively. Besides, these workers are entitled to DA annual increment rupees 70, 80, and 90 per year respectively. The state wage structures were introduced through the negotiations between the management of ONGC contract laborers in Mumbai. Similar wage structure was introduced in Chennai. Thus, the contract laborers of ONGC in Assam, SS zones, and Assam Arakan Basin zone are getting rupees 1,500 per month, which is far below the prescribed rate of minimum wages payable to the laborers in any state of India. The union added that IOL Dulyajan pays the wages of contract labor at the rate of rupees 243 per day, while the IOC Guwahati refinery pays wages at the rate of 133.26, at 139.09, 145.09 per day.
Mr. Dasgupta, the waste part perhaps you may not emphasize.
No,
Your main concern is their engagement.
Yes.
You can concentrate on that part of the word which talks about engagement.
Now, then your lordship,
Because until and unless they are engaged, the payment part won't come.
no. So therefore, Lord, a settlement was arrived at
Come to that part of the award where settlement has been discussed.
No, that settlement, your lordship, is they have
It has been quoted here.
48.
Page 48.
Page
Terms
48.
of the settlement.
Job, Lord, page 48, terms of settlement. Job security of the contract worker. Both
Yes.
the parties agree that as per the existing practice, whenever contractor of ONGC changes, list of the contract workers engaged by the previous contractors will be provided to the new contractor. so that the same contract workers can be engaged. That is very much important. Sir.
Yes.
The contract workers who were engaged on 24/6/2008 and continue to be engaged till date, and also those who were engaged on 1/1/2011 and have continued till date will only be eligible to be included in the list. But this is the problem, sir. We were working, these persons were working on 24/6/2008, but they did not continue to work up to the date of 1/4/2012. Have continued till date will only be eligible to be included in the list. However, the contract labor can be removed on the following ground. Let us age of superannuation, etc. Wage revisions, that is, they have some bearing, but so far present case is concerned, we don't have any such grievances of wage revision because we are not in practice. So here, these are okay. Now, Miller, just one of the
At page 50.
Page
Page 50, the third paragraph from bottom.
It is agreed by the union on the principle of ONGC management that these benefits of the contractor shall be extended to the concerned contractor with effect from 1/4/2012. And the settlement will remain in force for 5 years. So that has expired in the year 2017. But it is being secret, no fresh settlement has been here. After it is being continued. Okay. Settlement remain in force for a period of 5 years from the date of signature minimum wages for all notified central government. So here we are PF benefit, ESI benefit, all these benefits are being extended by the ONGC Limited itself. Now, we have to, now your lordship come to page 56.
Yes.
Now, after this settlement, the person concerned who were not in service as on who were in the service as on in the year 2008, but not in the service in the year 2012, Lord, for their given for them an application under section 31A was prepared before the
33A. 33A, not 31.
33A. Sorry. 33A was prepared before the industrial.
That you have said you have withdrawn.
That petition was withdrawn.
After the award, you have withdrawn
Otherwise,
it.
Lord, what happened? We are under some certain compulsion, Lord, because there was a clause in the settlement itself that all the pending cases have to be withdrawn. Otherwise, they will not give effect. All the pending cases, I will refer. So, in such circumstances, Lord, this has to be withdrawn with the leave to agitate the matter as a point. Because I am coming to that clause that you do not withdraw your case, then we will not give away. Under such compulsion, Lord, this has to be withdrawn. That your lordship will find in this settlement itself.
Serial number 6. Page 50.
Now you have page 23, your lordship.
23.
Page 23. That is the condition. Clause 6 of this settlement. So I have annexed that settlement. But page 23. This settlement starts from page 17.
Understood, but it's a part of the award at page 50.
Oh.
50.
Fine.
50.
That is also purpose.
The settlement has been extracted. Page 50, serial
Yeah.
number 6.
Which are pending case.
Yes. This is verbatim extraction of the settlement in the award. Yes.
So for that reason, Miller would have to withdraw this case under section 33A. That was our compulsion. Otherwise, Miller would not have withdrawn this. Because if we do not withdraw this application, then we will not get the benefit of the marriage process for the other. Now, Miller, we the lordship will come to the order page 56. The petitioners are represented by Ms. S. Borua, the president, and Mr. J. K. Vaishya, assistant secretary, Mr. Sachin Sir, contractual labor union, along with Mr. Sachin Sir, learned, and Mr. Learned. The opposite party appeared through their learned advocate, Dot, along with Sachin Sir.
This has been withdrawn. This has
54 of the
no need of reading. This has been withdrawn at page 57.
yes,
In view of the above circumstances, so and so is withdrawn without cause. The liberty person.
Petitioners are allowed to withdraw the miscellaneous case without any cause. However, they are at liberty to pursue their cause in proper forum. In the result, this miscellaneous case is disposed of on withdrawal. So, Lord, after withdrawing this case, Lord, that was withdrawal in the year 2015. Then, Lord, we approved for this honorable court for a day. So that the person concerned who were working in the year 2008, but they were not working in the year 2012, their case may also be included in the fair wage policy. That is, to our lordship, comes to our prayer of the petition. In the witnesses aforesaid, the petitioner prays that your lordship may be pleased to admit it. So, like, the contract laborers who were disengaged prior to 2011, 12, 1/4/2012, as shall not be engaged as a contract laborer in the event of engagement of the new contract laborers as ensured by the fair wage policy, which with respect to the contract laborers who were in their job on so far this settlement is
Now, Mr. Dasgupta, two questions. Two questions you have to answer. The award is not the subject matter of challenge. Number one, award has taken into consideration a settlement, and in fact, in the terms of the settlement, the award has been passed.
Yes.
Now, settlement, as you know, under Section 18, is binding.
Yes.
It is binding upon the union, and union is now espousing this present petition. Now, isn't that a bar for you to when the award itself is not challenged.
Yes, that is correct. When this award itself is not challenged, we cannot say that they should be included. Now,
You had agreed to, you had
yes,
agreed
your
to a
lordship is
term.
absolutely correct. To raise this allegation, we have to challenge this award.
Award, correct.
We have to challenge this award, and we can effect for some order to be passed by this honorable court to the effect that the person concerned who were working in the year 2008,
Exactly.
they should also be included. We should have challenged this.
And the second hurdle for you is that the award is based on a settlement where you are a signatory, union, and award terms of settlement is binding under Section 18.
Yes.
You cannot agitate.
Yes, we cannot agitate. That is our problem, because even we cannot challenge this award also, because if we challenge that award, then we will not get the benefits of the privileges for it.
No, so you could have made a challenge to that part of the award by which a class has been created, that one who is working, continuing to work after a particular date and still working.
Yes, still working.
You could have said that
2008, still working 2008.
the problem has arisen because of the use of the terms who are continuing to work.
Continuing to work.
You are also having some members who at that time were not in service.
As on 1/4/2012.
Correct.
But we were working in the
Earlier.
working. So we could have challenged that award. But we could not challenge this award because of the fact that if we challenge this award, Lord, the benefits as were granted to the by the fair wage policy will not
Is there any case law saying that in spite of the provisions of Section 18, you can come before a court or make a challenge?
Yes, I shall take it up. But my contention before your lordship, we are at this stage. All right, these persons were retained before 1/4/2012, but they were working in the year 2008. But these persons were retained before 1/4/2008. Now, whenever some new contractor will come, so if these retained employees are citizens of India, then their case should also be considered to the effect that they can be engaged as a contract laborer. And if they are engaged as a contract laborer in view of the provision contained in 25A, then, my lord, they will be protected by the...
That provision is also directed in nature. The Contract Labor Regulation and Abolition Act of 1970, which you are referring, and which is 25H, isn't it?
The Industrial Dispute Act.
Industrial Dispute. That is also directed in nature, not mandated. Discretion is given to the employer. You cannot have it as a matter of right. 25H.
Basically, definition of the principal employer and employer are more or less same. If your lordship goes to the definition of 22G of the Industrial Dispute Act, and if your lordship goes to the 2G of the Contract Labor Regulation Act,
Correct.
they are more or less same. Parameters are identical.
Let us read 25H. Let us read 25H of the ID Act.
25A. Where any workmen are retained and the employer, here is the employer proposes to take into his employ any person, he shall in such a manner as may be prescribed give an opportunity to the retrenched workmen who are citizens of India to offer themselves for re-employment, and such retrenched workmen who offer themselves for re-employment shall have a preference over the other person. Now here, my lord, the employer wants to employ through some contract, not directly. Then also, my lord, this will be applicable in view of the section 2D of the definition as contained in principal employer.
Okay.
Then your lordship, let me take it up so far as your lordship proposal is concerned. On day after tomorrow, I'll
No, we are finishing up. You can give the case law later on, but we are finishing up the hearing.
All right.
We're complete the hearing.
Because so my endeavor before your lordship will be that the person concerned who were working in the year 2008, but who were not working on 1/4/2012, their case should also be considered when the principal employer proposes to take any person in their employment to either through principal direct employment or to the employment to a contract. To that effect, some reaction, if the reaction is given, totally they may be better. Or probably, I don't know to what extent they will be benefited. Time will say. Otherwise, we don't have any other option at that point of time because I was their lord. I cannot say, no, you don't take it. More than 300 workers will be deprived. They are still working. They are getting about 30 to 40,000 rupees. They are getting the
And in
ESI,
the second
ESI benefit. They are getting the PF benefit.
in the second writ petition, there are 85 numbers of petitioners. 85. You
Your lordship, without mentioning the numbers of the person, if your lordship indicates that the person concerned who were working in year 2008, but not working on 1/4/2012, their case will be considered. Whether my union employees or other our union employees is immaterial. Material question will be that the person concerned who were working in the year 2008, but who are not working on 1/4/2012, their case should be considered while engaging the contract.
Yes. Madam, you have anything else to say? Come this side. What is your name? Doesn't matter. Yes. What is your case? How many petitioners are there? 85.
Due to the thing is,
Yes. You have the idea, Industrial Disputes Act. Take it from a senior colleague. Industrial Disputes Act. Read section 18.
25/8
Read section 18.
18 persons on whom settlement or settlement right by agreement otherwise that the court of constituted finding the party recommend on the party settlement right binding on all parties. The all parties here is the court.
The rest of the part you may not read. 18.1 says a settlement arrived at by agreement between the employer and the workman, otherwise done in a course of conciliation, shall be binding on the parties. You 85 number of persons, you are the member of the union. The settlement has been arrived at by the union with the ONGC. That is binding upon you. And that settlement has taken the form of an award. Award is not the subject matter of challenge. Can you come to a report by saying that you need insertion in the award without there being a challenge? And first of all, how do you overcome the hurdle of 18? Once you settle something, once and for all matter gets, there is no question of further litigation. That is the object of a settlement. And this statute in particular has given a finality that once settled, it is binding upon. You cannot just turn around and say that I am not agreeing. If you are not agreeing, there should have been a settlement. I think 18 will create a major difficulty for you. 25H, we'll see what we can do under 25H. That depends upon what Mr. Sayola says. Okay. Yes, Mr. I think we have indicated where we are having some difficulty.
My lord, here, my lord, agreement, my lord, my lord, because they are not the workers of the ONC directly. They are
Just a minute. Madam, this 85 persons whom you are representing, are you disputing that they disputing the fact that they belong to the union? They are part of the union. Typical. Yes.
It is, my lord,
But if it is settlement, then it will be binding to all.
Yes.
Whether he is an employee of the union or
No,
not.
but here there is no conciliation. It was in terms.
No, but
It is binding upon the parties. They are part of the union.
no, it is a conciliation.
If it's conciliation is further worse, then it is binding upon
I
everything.
will point
Yes,
out.
yes, you're correct.
Otherwise, not why. Because a conciliatory settlement is binding on
Yes, yes.
all.
You're correct.
Otherwise, because I have annexed the settlement.
Okay.
my lord, this is a settlement, my lord. Like closest, my lord. Settlement, my lord, they themselves, my lord, agreed to that a particular cut-off date. My lord, because we need not engage them, my lord. ONC does not engage. It is the contractors, my lord, they have to engage it. Main thing is this, my lord, wage revision and other things. These things were done by this settlement. Those who will be engaged by the contractor, they will get this type of my lord, wages and other. That was the main crux of the matter.
Notification 870.
What? That's the settlement.
Is clear. Memorandum of settlement arrived at under section 12. 12 is says about the conciliatory.
So this is the settlement which was subject matter of the my lord, reference also in the total labor.
Because
Industrial labor.
12 3. So there is no such dispute. And this settlement is binding throughout the country, everywhere. Everywhere.
Yes.
Bombay, Gujarat.
And virtually, my lord, these settlements are done for 5 years and after. So that is also expired, my lord. Now they can go for fresh settlement, my lord. How this court will, my lord, give any relief, my lord? Because cut-off date has to be given, my lord. Because number of persons are there, contractors are limited. So they want from the labor. So those who are working, my lord, they wanted to take those. So requirement is very less, my lord. Numbers are very more. That is why cut-off that has been declared. And nobody can go beyond that, my lord. That is binding matter. And once he need not, my lord, engage anybody, my lord. It's a contractor who can. Yeah, commission, my lord, it is binding, my lord. They cannot do it. My lord. It's subject matter of the Japan's case, my lord, labor code. That has not been challenged because that was also, my lord, the entire agreement statement has been quoted. So there is no interface.
No.
And second case, my lord, particularly the certificates they have annexed, these were all prior to that matter.
No, councillors fairly said that they were engaged prior to the cutoff date of 1/4/2012.
No, not 12, my lord. That another date, my lord. Because if you also see that that is there, who were engaged as on 24/6/2008, my lord, at page 48. So 24/6/2008, they are engaged prior to that. Most of them. 24/6/2008. Most of them were engaged prior to that. The earlier date also, not the second date. Yeah, my lord, the court cannot, my lord, uh, I go for a press settlement, my lord, again. And there is only two that.
But nature of settlement has already been expired, but I have some limitation I know very well. So what is settlement is concerned. So I am on 20 implementation of section 25(8) as well as
Definition.
25(8)
2G.
is any exchange for he may be in that zone or he may be prior to that.
Both these two writ petitions having raised an analogous issue are taken up for disposal by this common judgment and order. While WP 6045/2016 has been filed by the ONGC Contracted Labor Union, WP 1794/2022 has been filed by 85 numbers of such contractual laborers. At the outset, it is to be noted that it is an admitted fact that the 85 numbers of petition in the second writ petition are also members of the union which is the petition in the first writ. before going to the issue which has arisen for adjudication, comma, the facts of the case may be narrated in brief in the following manner. The an industrial dispute was raised for consideration in the year 2009 before the Central Government Industrial Tribunal, Guwahati, bracket hearing of the CCI, bracket. During the pendency of the pendency of the reference, comma, a settlement was arrived at between the ONGC and the union after a conciliation dated 18/7/2012 at Gujarat. The terms of the reference is, however, required to be mentioned, which is expected herein below. Terms of the reference. The learned tribunal had accordingly passed an award dated 25/9/2014, 25/9/2014, in reference case number 04 of 2009, in terms of the settlement arrived at after a conciliation procedure. The relevant part of the award, which has incorporated the terms of the settlement.
One thing, I'm sorry, after the conciliation proceeding at Gujarat,
Yes, sir.
that
Yes, sir. Yes, sir. The relevant part of the award, which is expected herein below. Page 47. From it. It. The aforesaid settlement, which is a part of the award, makes it clear that the benefit which would accrue upon the workman would be such contract workers who were engaged as on 24/6/2008 and continued to be engaged till date, and also who were engaged on 1/1/2011 and have continued till date will only be eligible for the privileges and benefits of the settlement. The present list concerns such members of the union who are also petitioners in the second writ petition, who were engaged prior to 24/6/2008, but was not continuing as on the cutoff date, which was fixed on 1/4/2012. The relief which the petitioners are praying for is that consideration of the case for engagement as and when works are taken up by the ONGC, being the principal employer, to any contractor. Full stop. I have heard Sri A. Dasgupta, the senior counsel for the petitioner in WPC 6045/2016, assisted by Vidas, whereas MS B. Talukdar, Senate counsel, has appeared for the petitioner in WPC 1794/20. I have also heard Sri G. N. Sahewala, London senior counsel, assisted by B.K. Das,
My lord, and annexing in the first case, my lord, and BK Das.
assisted by Sri B.K. Das, as well as the annexing Senate counsel for the ONGC. The materials placed before this court have also been carefully examined. Before proceeding further, the prayer made in this petition is to be taken note of, which is extracted herein below, page 9. Prayer. Prayer made in WP 6054 46045. In the second repetition, the prayer is substantially the same, with some more particulars in the form of praying for engagement of contracted laborers who were disengaged prior to 1/4/2012. Full stop. Para. Sri Dasgupta, the senior counsel, has submitted that in fact an application under section 33A of
Yes.
the 33A
Capital.
of the Industrial Disputes Act 1947 was filed not to change the service condition. However, after the award,
Before award. Because if we do not withdraw the case, the award will not be passed.
however, after the terms of the settlement,
Or
the application was withdrawn,
on 8-9,
which was
18-9.
which was done as a part of the settlement itself.
Because our award was passed on 25-9. We have to do it on 18-9.
And thereafter, the award was passed. Full stop. Sri Dasgupta has also referred section 25A of the Act of 1947, which relates to re-employment of retrenched workmen. Full stop. He submits that the petitioners should be given the benefit of such provision of law. Full stop. He further submits that the definition of employer appearing in section 2G of the Act of 1947 is similar to such definition of principal employer appearing in section 2G of the Contract Labor within bracket Regulation and Abolition bracket close Act of 1970.
Retrenchment definition is also there, my lord. 200.
It is the submission of the learned counsel for the petitioner that when there is no material difference between employer under the Act of 1947 and principal employer under the Act of 1970, the provisions of 25H of the Act of 1947 should also be given to the contract laborer.
But my senior friend suggested that may kindly be incorporated. 200, otherwise they will not understand this. So for the definition of retrenchment is concerned.
That part we are not touching.
No, that's all that.
By referring to the prayer, it is submitted by the petitioner that as on today, the numbers which had existed earlier had substantially reduced, and therefore a direction may be given that as and when a new contractor is engaged, the cases of the petitioners may be directed to be considered for engagement. And in such case, the fair wages should also be directed to be given to the petitioner. Per contrast, Sri Sahiwala, the senior counsel for the ONGC, has submitted that the writ petitions are misconceived. Full stop. He submits that the award dated 25/9/2014 has been passed in terms of the settlement arrived at between the parties. And unless the said award is the subject matter of challenge, the relief claim cannot be given. He otherwise submits that under Section 18 of the Act of 1947, the terms of the settlement are binding on the parties. He further submits that the present settlement is after a conciliation, and therefore the binding effect would be on all concerned. And once the members of the union, once the union who represents the members and the petitioners in the second case have agreed upon certain terms, they cannot be allowed to turn around and make additional and claim additional relief, which would be in the teeth of the statutory provisions laid down in Section 18. The senior counsel, however, fairly submits, and the senior counsel further submits that the provision of Section 25H of the Act of 1947 would not be applicable at all, as the same is for retrained workmen, and in the instant case, that issue has not arisen for consideration at all. The senior counsel, however, fairly submits that it is open for the union to have a new settlement, to approach for a new settlement. The rival submissions have been duly considered, and the material code have been carefully examined. From the prayers made in these two repetitions, it becomes apparent that a direction has been sought for to give the petitioners the benefit of the award in spite of the fact that the award is based on a settlement arrived at by the union espousing the cause of the petitioners, which was, and that too, after a conciliation. A bare producer of the settlement, which has been annexed to the writ petition, would reflect that the same was arrived at after a conciliation proceeding held on 18/7/2012. Section 18 of the Act of 1947 lays down regarding the binding effect of settlement and award upon lays down upon whom the settlement and award would be binding. While subsection A lays down that the settlement arrived at by agreement between the employer and the workman, otherwise than in the course of a conciliation proceeding, shall be binding on the parties to the agreement, comma. Subsection 3 makes it clear that such settlement arrived at in course of a conciliation proceeding under this act or an award of the labor court, comma, tribunal shall be binding on all the parties to the industrial tribunal, shall be binding, comma, amongst others, on all the parties to the industrial tribunal. Full stop. In the instant case, comma, in the instant case, comma, as noted above, the award dated 25/9/2014 has been passed solely in terms of the settlement. Full stop. As expected above, comma, the terms of the settlement state that the contract workers who were in the first line. This court is of the considered opinion that when a settlement was arrived at, which also took, which was also translated in the form of an award, comma, the same union cannot take a U-turn and make further claims which is not in terms of the settlement. Full stop. The matter would have been different if the award was the subject matter of challenge in a writ petition, which, however, is not the case. Full stop. In that view of the matter, comma, the relief claim, comma, in the considered opinion of this court is not liable, is unsustainable, and therefore cannot be granted. Full stop. Reference was made to section 25(8) of the Act of 1947 by bringing the analogy of the definition of employer and principal employer appearing in the two acts. This court, however, is unable to accede to the same contention as the connotation of section 25(8) is wholly different as it relates to re-employment of reference workmen. In any case, comma, after a settlement was reached between the parties, comma, it would not lie on any parties to the agreement to claim something which is not, which was not agreed upon and not in conformity with the agreed terms of the award, agreed terms of the matter. Under those facts and circumstances, this court is not inclined. This court is of the opinion that no case for interference or passing or granting of any relief is made out, and accordingly both are dismissed. full stop. This court, however, leaves it open for the parties to reach to 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 reach any further settlement for redressal of the grievance, which has to be done by strictly following the strictly in accordance with law. Yes.
Respondent number 8, as the divisional head assistant in the Public Works Road Department, Madhuri District Territorial Road Division. The ground of challenge basically is that the seniority criteria, which is the basis for the promotion, has been violated. And
Which rules are applicable?
we have stated paragraph 19 that the Assam Public Works Directorate Ministerial Establishment Service Schools.
Is it the
My
This is the rule?
my friend did petition is half-day.
No. Which is the rule?
Not exactly there. We have discussed now actually.
No, we just want to know what are the rules will come to you. So the rules which he is referring to, are you disputing that these rules are not governing the field?
My lord, I spoke to the chief engineer yesterday only, my lord. He told me it's not there.
What is the post?
My lord, the post is the subdivisional head assistant. My lord, divisional head assistant. I will go from the facts, my lord.
No, since he's made a statement that it's upon the seniority.
Well,
I would like to have a look at the rule criteria.
my lord, event is honorable court, wide order dated 20/09/2022, specifically directed my senior friend to apprise this honorable court that based on what service rule this recruitment has been carried out.
Exactly. Would like to.
Exactly, my lord. Without the rule, my lord, they cannot. I am coming to that point.
Okay.
Let him finish, my lord. I will just perform my affidavit.
We are finally hearing this, sir.
I am ready, with my friend.
Yes,
I'll
sir.
continue.
What is your name? Dudul.
Dudul Kumar Payang.
Yes, Mr. Priya.
My lord, may the page to turn. Page 34, my lord, is the nectar 1, my lord. The initial entry of the petitioner in the service.
Page 31.
Page 34, my lord. Page 34, annexure 1. Office of the Executive Engineer, PWD, Jorhat, West Road Division, my lord.
31.
Yes, my lord. Page 34, annexure 1. This is the type copy of the original one, my lord. Shri Dudul Kumar Payang, Master Labor under the Masudi Road Subdivision, is hereby appointed as the lower division assistant. Temporary in the scale of pay of joint plus other allowances.
What is the date?
My lord?
Date?
Yes, my lord. Date is my lord, it is 02/09/1993. I was, my lord, appointed as a lower divisional assistant state division. Then I continued, my lord. I joined also. Then, my lord, at page 38, annexure 3.
Where do you get the date?
The date is
date is in the below, my lord. Joining report, my lord, may be pleased to find at page 37, my lord. Wherein the reference made, my lord, your letter number nil dated 02/09/1993. Page 30 is the type and the 37 is the original one. Then, my lord, I was
29/1993.
02/09/1993.
Appointed as LDA.
In the cadre of lower division S.
LDA.
Then, my lord, at page 38, the promotion order, my lord, in the chain of vacancy caused due to the promotion of the ancestors of the UT assistant to the post of the divisional head assistant Tutul Payan, LDA of the Masudi Road subdivision is hereby promoted temporarily to fill up the backlog vacancy reserved for ST pay. The scale of pay of the so plus other allowances is admissible from the date of joining and placed in Durhat West Road Division with immediate effect until further order. My lord, may kindly note the date. This is the promotion order on 20/07/2004. Then
As UDA.
as UDM, from LTA to UDM.
Okay.
Then, my lord, I was released from the office of the Assistant Executive Engineer, PWD Masudi Road Division, Gormore, as per the Executive Engineer's Office Order number dated so Sri Dudul Kumar Payak, LDA, under the Masudi Road Division, is hereby released from this office today on so that, my lord, I was released to enable me joining in the, my lord, from the office of the Executive Engineer to the, my lord, other division, copy to the PWD Durhat West Division. Then, my lord, I was continuing. Then, my lord, there are certain transfer of employees also there at page 44, annexure 5. Is, my lord, in the interest of work, the following office assistant of the Durhat West Road Division are hereby transferred and posted as whom again seeking their names with immediate effect until further order. Name of the incumbent from Sri Dukul Kumar Payang, UTA, Office of Durhat West Division, to my lord, Durhat West Road Division. This is an arrangement made, my lord, but my position as the UTA was checked. Then, my lord, one important document, my lord, may be pleased to find at page 48 by skipping the page 47, my lord. These are some arrangements has been made, changing of rename of the divisions, but it's not so vital. But page 48 is vital, my lord. And letter of, my lord, issued by the executive engineer, PWD Durhat Rural Road Division to the executive engineer, my lord, PWD Masudi Road Division. My lord, from this letter, my lordship may be pleased to find the name of the petitioner is at serial number 6. Page 48, my lord, annexure 7. This is an important document, my lord. Why I am referring, my lord, may be pleased to find that this Dudul Payang had been working, my lord, in this division. This is a letter dated 18/3/2019. Lord, in fact, I am working from in this division from 1st of March 2019, and therefore, my lord, this letter at 18/3/2019, Sri Dudul Payang, my designation, my lord, may kindly note, UTA assistant come head assistant has been shown. My lord, what has happened at this relevant period of time? The post of head assistant in this division was lying vacant, my lord. That's why, my lord, I was entrusted with the charge with the office of the head assistant in the executive engineer, my lord, PWD Durhat Rural Road Division. Then, my lord, this arrangement continue, and I was also allowed to draw the salary of the Rural Road Division. And this letter, my lord, at page 50, and another important document, my lord, in pursuance of the Deputy Secretary PWD notification number, the Durhat ASP subdivision 2 is under the office of the executive
But
engineer.
tell us one thing.
My lord.
Tell us one thing.
My lord.
You have been stated to be an employee under the PWD Mazuli Rural Subdivision.
My lord.
But prior to that, you were transferred to Durhat.
No, I was in Durhat, my lord, but at that relevant period of time, this subdivision was not created. So later on, it had been created, and I was, my lord, posted in this, my lord, Mazuli Rural subdivision.
When?
My lord, it was
Initially, you were in Mazuli.
Madhuri.
2004, you got promotion.
Right.
Then 2005, you were transferred to Jorhat West Road Division.
My lord, I was posted in the division on 1st of March 2019. My lord, my service book reflects the same.
Where you are posted in Majuli.
Yes, Madhuri. And
Where have you stated?
my lord, I have stated in my affidavit in reply filed, my lord, in connection with the affidavit filed by the government, my lord.
1st of March.
Yes, my lord, 1/3/2019. My lord,
Posted at Majuli.
yes, my lord. My lord, may be pleased to verify the said fact, my lord. In my affidavit in reply, I have annexed my service record, my lord, that my existence in the Madhuri division from 1/3/2019.
Okay, thereafter.
My lord. Then, my lord, what has happened, my lord? This private respondent, my lord, who was an employee of the Durhat NSC division, my lord, may be pleased to find from page 54. This is the first time this person came, my lord. Page 54. Mr. Mridu Pavan Soikia, Senior Assistant Office of the Executive Engineer, PWD Road, Durhat NSC Division, and so and so. Temporary attachment in the Office of the Executive Engineer, PWD Madhuri Road Division. You are hereby informed that you have been attached in the Office of the Executive Engineer, PWD Madhuri
Midul
Road
Pavan
Division.
Sekya is
Yes,
phone number.
respondent number 8, Miller, whose promotion order is under challenge. My lord, may kindly note the date of page 54 document.
47.
54, yes, dated 4/7/2019. The first time he came as an attached employee, from the NSC division, Durhat NSC division, PWD Road. You are hereby informed that you have been attached in the Office of the Executive Engineer, PWD Madhuri Road Division, by government order number dated so and so. You are hereby instructed to report to the Executive Engineer, PWD Madhuri Road Division, Madhuri immediately. So, my lord, he was attached on 4/7/2019. Then, my lord, suddenly this impugn order at page 55 came to be passed. In pursuance of the government number so and so, Sri Mridu Pavan Soikia, Senior Assistant of this division, he is thereby promoted to the vacant post of the divisional head assistant against the original strength of division in the pay band of so and so, so and so, so and so. His promotion will be effective from the date of joining in his promotion.
Date.
My lord,
Date.
order dated, my lord, is 15/2/2020. In the below, just, my lord, in the signature is reflected. So, my lord, the very basis for this promotion, my lord, is happens to be the seniority, come and other eligibility criteria qualification is there. But, my lord, from the very record it exists that I was existing in this PWD Madhuli District Territorial Road Division from 18/1/2019. And, my lord, this person came off date, my lord, on 4/7/2019. So, my lord, he cannot, my lord, supersede me from the, my lord, criteria of seniority. That is the basis of my challenge, my lord. And secondly, thereafter, my lord, I hesitated my grievances before the respondent by filing several, my lord, representation, and the respondent also took up.
No,
My
Mr. Priya,
My-
the seniority is counted in the feeder cadre or from the date when he has been attached to a particular office.
the particular the existence, the cadre of the Madhuri Rural Road Division, my lord, is maintained. The incumbent when he come and join. And
No, the seniority would be counted for the office where he joins
yes,
or in the feeder cadre which is substantially posted.
no, my lord, from the office where he
Suppose
joined.
person A
Fine.
is working for 10 years in a post
in a
which is a feeder cadre.
Fine.
And on the 11th year, he is taken to another office.
other
And person B is working for 5 years
five,
in the second office.
second of,
Can B says that no, I am senior to A?
no, my lord, and if the feeder cadre promotion criteria is also considered, my lord, then also I am senior. I was promoted in the cadre of upper divisional assistant in the year 2004, and this incumbent, my lord, promoted in the year 2013. in the Peter Cater, it is available on record.
He junior to you.
Yeah, I am junior to in the Peter Cater of upper divisional assistant, where from the promotion is made.
To division assistant.
Yes, yes.
Where do you see it?
My lord, if my lord may be pleased to take up the affidavit, my lord. No, my lord, these things came later on when the affidavit has been filed. If my lord may be pleased to take up the recent affidavit filed by the respondent, my lord, filed on
Filed on 26/5.
26/5.
Additional affidavit.
Additional affidavit, my lord. Just one document will reveal, my lord.
That is the case, man. It's additional affidavit.
My lord, at page
না, আপনি দেখাই
my lord has find the affidavit.
Yes, yes.
My lord, in this affidavit, the seniority annexed 3 document, my lord, I am referring. Seniority list of UD assistant in the office of the executive engineer, PWD Madhuri District Territorial Road Division, wherein, my lord, if my lord may be pleased to find the date of joining, my lord, date of promotion of the UDA in the department, my lord, Sri Mridu Prabhan Soikia, shown to be 12/3/2013, and Sri Dudul Kumar Payeng on 02/08/2004. So, my lord, on this count also, my lord, if the rule says that, it should be from the Peter Cater, it should be counted, then also, my lord, I am senior to him. So, my lord, one important thing is that, till date, the department has not come up specifically stating that what service rule they have followed. And in our petition, my lord, we have categorically said that this is the service rule is applicable, but they have neither denied, my lord, nor accepted. That's why, my lord, this honorable court, my lord, on the last occasion also, by the order dated, categorically, my lord, directed that the what service rule they are following, it should be made known to this honorable court. My lord, my case is very clear, my lord, that I am on the both counts. I am senior from the very record, my lord, which my respected senior friend has produced by an affidavit, my lord, that in the Peter Cater as well as existence or in the joining in the establishment of the PWD Madhuri Road Division, my lord. I joined on 18/1/2019, and this man came, my lord, on 4/7/2019. 6 months junior to me.
Yes.
After this promotion petition, my lord, cannot, my lord, sustain the scrutiny of my lord.
What is this rule?
Uh,
Assam Public Works Directorate Ministerial Establishment Rules of 2021.
my lord.
You have produced this rule.
Yes, my lord, we have produced this rule, and we have said that this is the rule applicable for the promotion purpose, my lord. But they, in paragraph 19 of my writ petition, my lord, I have categorically stated, but in the affidavit filed by the state, my lord, they have not denied a
But this apparatus rule came into force in 2021.
That is correct, my lord. But this is the amended part, my lord. This is the amended part, and before this, my lord, there was an unamended part. That's why, my lord, this honorable court wanted to know that which part of the rule, or by following the what rule you have
This is
promoted.
not an amendment.
My lord, it is the after 2021, my lord, there was another rule, other rule that has been repealed, my lord. If my lord may please take up,
This is not an amendment.
if my lord may please to take up the order dated, my lord, 20/09/2022 passed in this petition, my lord. Paragraph 3 says, Rule 26 of the Assam Public Court Directorate Ministerial Establishment Circuit Rule, notified in the Gazette on 9/2021, has provided that any rules corresponding to the 2021 rule
Yes.
and in force immediately before commencement of the 2021 rules are repealed,
Yes.
with provision that all order made. So, my lord, once this repeal has been made, my lord,
See, 26 is a saving clause.
my lord,
26 has not mentioned any rule in particular.
in particular,
Anything which may be existing can repeat.
my lord,
But this is a new rule. This is not a corrigendum or an addendum
Right.
or any amendment.
then,
This
my
is a
lord,
new rule.
the department is the best, and they can tell my lord,
What is the criteria, number one?
Yes.
And whether they have followed the criteria.
criteria on that.
I will just,
Anything else, Mr. Bhuya?
no, if my friends are subsequent, I
And
will,
I want just a minute. And as per we may not hold that these rules are applicable, but in case these rules are there, which part of the rule says the seniority is to be taken into account?
the rule, say, rule 6, rule 5, is the superintendent part is not applicable. Rule 5, sub rule 3, the recruitment cadre be made by promotion on the basis of seniority come merit among the senior assistants of the service.
Division and head assistant is a superintendent.
The divisional head assistant has not categorically said. There is another rule below, the Assam District Establishment Ministerial Service Rule. In that rule also, certain provisions are made wherein other head assistant has been in the cadre of other head.
What about the 67 rule?
67 rules I am putting. In this rule also, it is said that by selection from among the supervisory assistants who have rendered not less than 3 years of continuous service as supervisory assistant in the deputy commissioner department. But directly PWD head assistant, which is the rule applicable. I have not found anything directly.
Service. Your 67 rule says that your merit deputy. Yes, Dhawal, what you
I will just take the back. I can take it rapidly. I think it is one.
Yes.
I will see dated 4 December 2019. It's partial modification of the department to the that merit private respondent.
Ari.
Yes.
Ari.
Thereby transferred and posted as Architect District Federal Road Division. So, my lord, this is the order by which this private respondent comes into this establishment. Then the next section. My lord, this is a seniority list of the senior resident of that the Majuli District Federal Road Division dated 31/12. My lord, will find only one. This is the private respondent type. It will take it. Take number one. My lord will find at that point of time, my lord, the requisition was not there. So she was my lord to one, to my lord first. Then my lord will come to the next stage. This is my lord the strength. How it is we had one post there, the line functional method. There then my lord the last page the second last page 155, what my friend was referring to now. That is most important that we have looked into it, my lord. My lord friend, it is seniority list of duty existent in the office of the Liquidation PWD Major Road Division. So my lord, here it is a seniority list, not affected. Now my lord, we find it, my lord, right or wrong, my lord, data my lord, the private responsibility is at number one and the liquidation is at number two. Now my lord, we take it, my lord, just put this number one, date of birth, date of everything, then this date of joining is the division. Well, the division. That is why I'm
The
reading
department or division.
that serial number 7, column 700. Working in division with effect from 5 to 19 and joining on 6, 12, 19. That is my private response. Whereas the restriction of pilot is fine. Working in division with effect from 81, 19 and included in this establishment. My lord, the establishment that is to seniority, my lord, he joined in February 2020. And if you go in the extreme right remark, my lord, you find this real number one, this private respondent, he has already joined on 2020 as head assistant. So meaning thereby, my lord, he was maybe for a day or two, he was senior to the writ petition. He came in first. So my lord,
15 is the subject matter of challenge.
challenge, my lord.
15 is not relevant.
No, from where we have, my lord, come to this. Unless this due to this my lord challenge, this set aside, it is not still not challenge.
The seniority list has given the details of two persons.
Yes, my lord. Only there is
There is one serial number 1, there is serial number 2.
my lord.
It doesn't say that the serial number 1 is senior to serial number 2.
My lord, we have to read
This is not the gradation list.
152, my lord. Page number 152.
But the reasons have you seen that Mridu Pawan Saikia is working in this division with effect from 5/7/19, joining substantially on 6/12/19, and he is working in the division from 18/1/19 and establishment of February 2020. What is the feeder cadre? Feeder cadre is UTA. When did the petitioner join the post of UTA? 2004. When did the respondent? Did he come to this establishment on his own volition, or did you bring him? Can you cause prejudice to a person by transferring him? He loses all seniority.
That is what I was.
No, think reasonably. You are working here 10 years. You are taken to different office by the office itself. There you become junior to all the persons because you have just joined. Where? Is it on his own request? Was the transfer made his own request? Show us the law by which one person loses his seniority on transfer, unless of course it's done at his own request. This will be totally against the policy. R8, who is R8? Yes, what do you say? When did you join UTA? Now, can you affect his seniority by his transfer? He shown this. How did he come automatically? No, he comes automatically. Are you disputing that he is not working here? You're disputing that he is not working. There are certain things we have to assume. Unless, of course, you say that he's not even working. If he's working, if the case is that he came to this office by his own request, he loses his seniority. How can a junior person be given? Federal division is the department. You are an independent division. See, we are making very clear. Unless you show some material that he came to this office not because of the director, not because of the order of this office, but on his own volition making a request, we may not. Without transfer can support his work. He is not required to show. The mere fact that he is working in an office. Then what is the list at 155? The executive engineer says that this division where he was working was included in the establishment of the undersigned from February 2020. So but he, if the criteria is seniority, and the seniority in the federal cadre has to be seen, not which date he has joined the federal cadre in a new office. It is the date is the crucial date is when he was inducted in the federal cadre.
And what there is no any record that he has transferred.
And what about this statement that in this establishment, this rural division is included in the establishment of the territorial road division? 20. Yep, 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 yep.
Then I was that has come.
Can you show us anything, any statute or any law which says that the seniority has to be asserted who are the office where you are working and not the department? Can you affect it? No, understanding of show us. Is there any statutory provision or any case? Or these are established principle unless that he comes on a request from his own, he may lose his seniority. But as an incidence of service, you transfer a person and cause prejudice to him so far as seniority is concerned. Is that fair? That we have understood.
I don't want to clarify. 849. My
49.
49 and expect 7th of May of 9. So this is a letter. This is a letter from the government of the the which which says below which have cited above. I am direct action for the provision of salary of the staff constituted road subdivision, which was erstwhile under the control of the division. But what they have done is subdivision of late created was earlier under the control of Durhat Rural Road Division. Then this subdivision came. There is no separate subdivision here. The characteristic which remain the upper division. He was attached them to initiative. I have brought my and that it was happened. And that is modification of the task. So there is no report of the division subdivision trade. The division go and work in subdivision. It is not a new officer transfer. Inter-departmental arrangement for this. For the
Purpose of the I have contacted your office as office order referring to the office order 21 or order. Uh,
50.
Five.
Yes.
But requirements of the Sonapur. There are
No, I was already there. Was already there, and serial number is the letter marked to me. It is letter to by Gormut for information. I was already there in this Madhuri Road. That time, but once this is the reference has been made to me, that's why the inter-department exchange.
Mr. Hawk, you read footnote 7 also. 7 you have missed out, Mr. Bia.
My lord, my lord.
7 is also important for you.
Yes, yes. And about Dudul Pai.
Vandana Bhai has to hand over to Dudul Pai.
That is divisional head. I was already there. Joining in respect of Sana was living Miller. So,
I think Mr. Mia, 52, 53, this you were already a senior assistant in Majuri Rural.
yes.
Okay, you here, I think you should have written not a senior assistant, but the post of the charge of the head.
Charge of the head. Exactly, Miller. That point. I
That is a mistake you have
that is the
done.
mistake I have made, Miller.
Because if you are
Vandana
mentioning
was holding the
if
charge.
you are mentioning the order of 21/6/2019, there is no requirement for you to join again as senior assistant.
Not required.
Yeah, because you have signed as senior assistant.
My lord is correct, my lord. I am wrong, my lord, because this joining it should be as a head assistant in charge.
And that was only an in charge basis. It doesn't make any difference.
No, no,
We are not giving you any additional benefit
no.
for a temporary arrangement.
The LPC also.
But we will consider the length of service in the Peter cadre. But what rules we have not been able to show. No, that is a district establishment. This is not applicable. District establishment is the DC office. I think the PWD rule, you have a copy of the PWD rule? Not the engineering service rule, the other one.
21 rules, which I have just brought.
No, that will not be applicable. That
Applicable
came
here,
into
not
force later on.
Yes.
No, 67 is only for this. There are few more rules, but that is not there. Okay. No, we are passing out. We already have some judgments. We won't go to the chamber and we dictate whatever is here in the part 3 ARB and a concept for the station. Also heard the art or the understanding concept, public works department, whereas free and hawk and concept has appeared for the private response number 8. Considering the subject matter in dispute, coupled with the fact that pleadings have been exchanged and as agreed to by the parties, this writ petition is taken up for disposal at the admitted stage. Full stop. Para. The issue is with regard to the promotion of the response number 8 by the impugned order dated 15/2/2020. Full stop. By the said order, the response number 8 has been promoted to the rank of divisional head assistant. Full stop. Para. The fact projected is that the petitioner was initially appointed as an LDA on 2/9/1993 in the Madhuli Road subdivision of the Public Works Department. Full stop. On 27/2004, he was promoted to the rank of UDA. Full stop. Subsequent thereto, he had joined the state post, and on 5/5/2005, he was transferred to the Jorhat West Road subdivision. Full stop. Sri Bhuya, the learned counsel for the petitioner, submits that on 1/3/2019, submits that though the document has not been annexed, the petitioner was posted at Madhuli by the order dated 1/3/2019, and to substantiate the said averment, a list of employees dated 18/3/2019 has been referred, wherein the name of the petitioner appears against serial number 6. Full stop. Sri Bhuya has also referred to an order dated 4/7/2019, whereby the private response number 8 was attached, person number 8, UDA was attached to the Madhuri Road division. Full stop. However, by ignoring the candidature of the petitioner, the impugned order was passed on 15/2/2020, whereby the response number 8 was promoted to the rank of divisional head assistant. Full stop. Sri Bhuya, Sri Bhuya has also referred to a chart which has been annexed to the additional affidavit filed by the petitioner on 26/5/2023, which shows that while the response number 8 has joined the post of UTA on 12/3/2013, the petitioner had joined such post of UTA on 2/8/2004. The learned counsel for the petitioner submits that the post of head assistant, divisional head assistant, should be filled up by taking into account the seniority, and there is no dispute to the fact that in the feeder cadre of UTA, the petitioner is much senior to the respondent number 8. Full stop. He also submits that the petitioner Sri Bhuya, the learned counsel accordingly submits that the imputed order dated 15/2/2020 is liable to be interfered with, and the benefit of the promotion be given to the petitioner. We urge our learned counsel for the department, however, submits that the petition is the misconceived one. Full stop. According to the learned department counsel, comma, the respondent number 8 was transferred to the present office at Mazuli on 4/12/2019, whereas the petitioner, is it 4/12? 151. Whereas the petitioner, but even in Mazuli, he had joined on 1/3/19. Petitioner,
From my service book reflect.
in this division, when did he come?
That is where from they have made this statement. There is no record.
Oh,
I was there.
Okay, whereas the petitioner, who was working with effect from 18/1/2019, comma, the state division was brought under the establishment of the Mazuli District Territorial Road Division only in February 2020. He accordingly submits that the projection made by the petitioner may not be correct. The Hawk, the learned counsel for the respondent number 8, has submitted that in the seniority list prepared for the office in question, comma, the respondent number 8 was the lone contender in the federal cadre, and therefore his promotion is not liable to be interfered with. He also endorses the submission of the learned department counsel by submitting that the establishment in question was establishment of the petitioner where he was working was brought under the office of the district territorial brought under the district territorial road division much later than the date of transfer of his client to the state office. The rival contention advanced by the learned counsel for the parties have been duly considered and the materials placed before the court carefully examined. Whereas it is not in dispute that the petitioner had joined the post of UTA on 2/8/2004, whereas the respondent number 8 had joined the state post on 12/3/2020, 12/3/2013. The parties are also in agreement that the criteria for promotion to the next higher cadre of divisional head assistant is done on the basis of seniority. Full stop. The question therefore arises for determination as to whether such seniority has to be reckoned from the date when an incumbent joins the particular office or from the date when the incumbent is promoted to not the is inducted in the feeder cadre. This court would this court is of the opinion that in a given case when the joining of an incumbent in an office on transfer or adjustment is done at his own request or the said incumbent had any role in such arrangement, the seniority of such incumbent may be affected. However, when such transfer, public attachment, public arrangements are done by the department in the interest of public service, affecting the seniority of an incumbent will lead to a situation of anarchy where not the anarchy situation uh, which is which will not only be against the service jurisprudence but would also lead to a floodgate to adversely affect the service career of government employees. If such a scope is left open, and in a given case, an incumbent can never can never have the opportunity of promotion if at the if at such time, he is transferred to another office by whereby he loses his seniority. The said proposition cannot be a reasonable position in the eyes of law. In the instant case, the chart prepared by the executive engineer, PWD Road Division, PWD Road, Majuli District Territorial Road Division has taken into consideration that while the respondent number 8 had joined the division on 5/7/19 and was substantially working from 6/12/19, the petitioner was working in the division from 18/1/2019, and the state division was included in the establishment of the Majuli District Territorial Road Division with effect from February 2020. It transpires that even for argument's sake, the date of working in the division is taken into consideration, the petitioner is working in the division from 18/1/2019, whereas the respondent number 8 is working from 5/7/2019. Therefore, from all angles, it cannot be held that the respondent number 8 is senior to the petitioner. Further, as has been held, as has been observed in detail above, seniority has to be reckoned from the date when an incumbent joins the feeder cadre, which in the instant case, which in the instant case would show that the petitioner is almost 9 years senior to the respondable age in the cadre of UTA. So, under those efforts and facts and circumstances, this court is of the unhesitant opinion that the impugned order of promotion dated 15 to 2020 is not sustainable and law, and accordingly the same is set aside. The respondents are accordingly directed to consider the case of the petitioner afresh and complete the exercise of promotion expeditious in accordance with law. It further made clear that since the respondent aide was working as a division head assistant, was there any stay order?
No.
From date of his promotion, that is 15 to 2020, the question of making any recovery will not arise.
Right.
What is your prayer?
For accepting pressure.
At this stage, you are making a prayer. Why?
I need to go.
We'll have it next week on a prayer made by Sri B. Purkast, counsel for the petition, just after a week.
Intimate.
Interim order pass will get to. If there is an interim, we'll fix the date. Please on just after on the prayer matter is adjourned to be listed on day 8. We listed on 13th of 14th of. Yes.
But, my lord,
Yes.
so this case, my lord, some interpretation from the contract labor regulation and evolution is required. So, my lord, to prior, for that reason, my lord, I would like to invite your lord to certain provisions of the law pertaining to the contract labor regulation.
The thing is for the FCI. We can have it for admission hearing.
Though it is transfer method, but some interpretation on contract labor regulation. What happened in this case?
You have exchanged the pleadings.
They have filed their affidavit. Now, before opening the brief, my lord,
The rest of the matters are connected.
draft of the matter, my lord, let me. Otherwise,
There is one 13 matter in the hearing column. No, in the hearing column there is a 13 matter 2013. T.U. Laskar and her S.S. Raman. 30, item number 16. Why?
There is a mistake for your pleading load. This is 17 loaded. 1790.
What is the matter about?
Regarding discussion of the
And why do you want replacement?
Lordship, after liquidation, Lordship, I liquidated my party. For that, I filed which is 1790.
There's one 80, 82 with 82 category. It's not open. Same. 21 and 22 are for vacation of stay or what? For extension? For stay order means?
Because there is a very what I might.
Okay. Pleadings have been exchanged.
My lord, take
PWD.
it. My lord, come on.
Let us see. Yours, I will take later. We thought it was a hearing matter. I will take it up later. Yes.
So one thing that I would like to clarify your thought. So say there is an establishment. In this that establishment, engagement of the contract labor was abolished. Subsequently, the notification whereby the contract labor was abolished was withdrawn. In exercise of their power conferred under Section 31. Now, after withdrawal of this, the FCI is under a notion that as it is withdrawn, only the contract laborers will be engaged and nobody can be engaged. That is their understanding, probably. There is an establishment.
Understood.
In that establishment, contract labor were engaged. And this contract engagement of the contract labor was abolished. In exercise of the
And that abolition order has been withdrawn.
that abolition order has been withdrawn in view of a judgment of the Bombay High Court. But anyway, that abolition order was withdrawn. Now they are permitted to engage contract labor in that establishment. This is the position. Now they are of the view that as they are permitted to engage contract labor, only the contract laborers will be
Understood.
engaged.
Who are you?
And no other employees can
Who
be
are you? Who are you?
I am a worker. I am not a contractor.
Okay.
There are about
What is your grievance?
There are about 35 workers.
What is your grievance?
No, let me. There are about 35 workers. All these 35 workers have been transferred from Tihu to Chalpua because of the fact that they are under impression that only the contract laborer can work here. That is probably not correct. Secondly, my lord, there is a circular. In that circular, it is stated, I am not a regular worker. I am an ancillary worker. No work, no pay. Our salary is not more than 25,000 per month. Of course, if I am entrusted with some additional work, then I will get some extra wage that they call it. Now there is a circular. In that circular, it is stated that while transferring this type of persons, they should not be transferred more than 100 miles away. Not more than 100 miles away. Now that order, that circular was not considered. However, in that circular, there is some contention that yes, you can deviate this circular, but for that reason, there must have some sufficient reason. Without having any sufficient reason, you cannot deviate this norm. Now, their reason is that as this is a establishment where we can engage contract laborer, no departmental worker will be allowed to work. Only the contract laborer could be.
From where do you find this? Which is the document?
Their affidavit. from their affidavit.
But the impugned order is otherwise at page 29.
No, blood, yeah, let me argument my own way, my lord.
Mm.
Then probably. Your lordship will come to paragraph 52
Of?
of their affidavit of fee. Then
Where did you file your affidavit? This is thing.
52,
December. Last period is December. Mr. Rasgupta, the affidavit unfortunately is not with the record. We'll have the affidavit in record and have it any other. Give a request.
let the matter be kept as part, Lord, because I have some other reason. Because this is
Part head, this
no,
every day this bench is changing. Cannot keep it as part head.
no, it will be
Today
very
bench
fine
pay,
with your
tomorrow it
lordship,
may not be bench.
Lord. This notion is creating a lot of trouble for the country, I am telling.
So, it appears that though affidavit in opposition by the FCI has been filed on December 2022, comma, the same is not with the record. Para office to verify and tag the state affidavit with the record and list this matter. After
Actually, it was filed probably on 2nd March 2023. It was filed on 2nd March 2023.
June to December, affidavit in opposition has been filed by the FCI, which however is not with the record. Do you have the filing number?
Yes, my lord. It is on 2nd. I will check it up.
I am not giving the date,
Yes.
but I have the filing to have the list when
And on 26th of this
20 June. Please not wait.
Interim order may carry it.
What is the interim order?
day of
Stay.
the
Interim order passed earlier to continue to the next zero. Yes, next. What about these matters?
The Lordship, this present repetition is on the item number 13. It's on a very narrow component. So it regards the review period, when the review should be done. Whether as per rule 10, rule 6 or the case 6 and 7, whether it should be done before 90 days mandatorily or not. To this effect, Your Lordship, there is a Denmark judgment of Deepak Mani, which specifically states that it has to be done mandatorily, shall be done before 90 days, which in my case was not done. So I'll take the Lordship straight to the suspension order. It is at page number 104. I won't trouble your Lordship with the background facts because that is somewhat
104.
10. The suspension order, the annexure 12, page 104.
Your Vijay Kumar Singh,
Vinay Kumar.
Vinay,
Vinay Kumar.
SC means superintendent engineer or what?
SE civil superintendent. So it's dated 1st of November 2022, and the second paragraph. Now, therefore, in exercise of the powers conferred by Sub-Rule 1 of Rule 10 of the CK rules, the officer Vinay Kumar Singh is hereby placed under suspension with immediate effect. Lordship, it is with immediate effect. Although this particular suspension order was handed over to him on 7th of November, but it is with immediate effect. And from 1st of November, this particular period was supposed to end by 29th of January 2023. But what they did, they reviewed it
without any review committee details in the mentioned in the extension order, which is at page number 106. It's dated 3rd of February. They extended it without mentioning anything as to on what ground it should be extended as per the mandate of Rule 10.6 and 10.7. They simply extended it, saying that disciplinary proceeding is under process, since disciplinary proceeding is under process in paragraph 6. That's it. And he was, of course, given subsidies allowance only of 50%. Now it has been increased to 10. I had no qualms with regards to that. So the whole gamut of this whole matter is whether it should be done within the 90 days. Now, in my humble submission, Your Lordship, I have just placed one. I like to place two judgments. One is the case of Deepak Mali. Paragraph 11. Union. These two judgments will clarify everything. First, the landmark judgment of Deepak Mali, 2010 2 SCC 222. At paragraph number 11.
You were suspended on 1st of November.
1st of November. And the extension is dated 3rd of February 2020. 90 days period.
3rd of February.
3rd of February. And the 90 days period would end on 29th of January 2023. Mandatory 90 days. Now, if your lordship comes to paragraph number 10 of the judgment of Deepak Mali, I'd just like to read out those two paragraphs, 10 and 11. Having carefully considered the submissions made on behalf of the parties and having also considered the relevant dates relating to suspension of the respondent, and when the petitioner's case came up for review on 28th of October 2004, we are inclined to agree with the views expressed by the Central Administrative Tribunal as confirmed by the High Court that having regard to the amended provisions of sub-rules 6 and 7 of Rule 10, the review for modification or revocation of the order of suspension was required to be done before the expiry of 90 days from the date of order of suspension, and as categories provided under sub-rule 7, the order of suspension made or deemed would not be valid for after a period of 90 days unless it was extended after review for a further period of 90 days. Para 11, the case sought to be made out on behalf of the Petitioner Union of India as to the cause of delay in reviewing the respondent's case is not very convincing. Section 19(4) of the Administrative Tribunals Act speaks of abatement of proceedings once the original application under the State Act was admitted. In this case, what is important is that for operation of sub-rule 6 of Rule 10 of the 1965 rule, the order of suspension would not survive after the period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither was there any review nor extension within the state period of 90 days, subsequent review and extension, in our view, could not survive the order which had already become
Could not
invalid.
revive that. Could not survive, could not revive.
Could not revive. I'm sorry. Could not revive the order which had already become invalid after the expiry of 90 days from the date of. And the contention that is been taken by the respondents herein, they have stated that since the order was handed over to me on 7th of November, therefore the 90 days period will start from 7th of November. And I received it on 12th of February. That is the contention. Then also, if we calculate from 7th of November for the 90 days period, that would end on 5th of February. And I was handed this extension letter on 12th of February. Even then also, if that has to be
Extension letter is 3rd of February.
dated 3rd of February, but I was handed over. Just like this suspension order is
No, there are two connotations. You have to hit on some other point. On the point of the when does the suspension take effect?
Yes.
What is the case law?
That is what Your Lordship I placed one judgment Delhi Development Authority versus AC
Purana.
Purana. There, at paragraph number 13, 14, and 15,
Hmm.
it's AR 1993 SC 1488.
Hmm.
As to when any order passed by the department would take into effect.
Hmm.
The contention that was raised in this particular case, in this AC Purana case, was that it would take effect when it is served. But that is not the case. The Honorable Supreme Court has said, whenever it is issued, any order passed by the department authority, that would take effect on that particular day, not when it is served upon the employee.
Where is it? Where is it?
I like to read out in the judgment, para number 13,
Hmm.
fourth line, the word issued.
Yes.
The word issued.
Read from the beginning of
Yes.
the paragraph.
It will be seen that in Janaki Raman also emphasis on the is on the stage when a decision has been taken to initiate the disciplinary proceeding, and it was further said that to deny the state benefit of promotion, they must be at the relevant time pending at the stage when charge memo or charge sheet has already been issued to the employee. The word issued used in this context in Janaki Raman, it is urged by learned counsel for the respondent, means service on the employee. We are unable to read Janaki Raman in this manner. The context in which the word issued has been issued merely means that the decision to initiate disciplinary proceedings is taken and translated into action by dispatch of the charge sheet, leaving no doubt that the decision has been taken. The contrary view defeats the object by enabling the government servant, if so inclined, to evade service and thereby frustrate the decision and get promotion in spite of the decision. Obviously, the contrary view cannot be taken. Next page, Your Lordship. Paragraph number 14. Issue of the charge sheet in the context of decision taken to initiate the disciplinary proceeding.
There are direct decisions on this point. When does the suspension take place? When does the termination or dismissal take place? These decisions are there. These are not directly on the point.
But
We are not on the point of 90 days. That is the settled law.
Yes, sir.
The point is when the 90 days from which date it should be reckoned.
Yes.
Now there is a difference between a suspension order and a dismissal order. There are case laws.
Right.
How to treat the date of effect of a suspension order and when from which date the order of dismissal is treated.
I,
Have you got those decisions?
I don't have that.
There are.
I don't have a
Directly this distinction is there. See, this interpretation of the word issue is in the context of a church sheet.
Right.
A decision has been taken. And this same analogy may also be applicable for a suspension, which will help your case. Unlike a case of dismissal.
This is with regards to the charge
Unlike
sheet.
a case of dismissal where it takes effect from the date when you are served with a
Served.
copy.
Served.
Suspension is a different connotation. There are case laws.
Your Lordship, in this case, charge sheet, the issue was with regards to the
Search sheet is not a suspension case.
No, no.
There is a difference between issue of a search sheet, issue of a suspension, issue of any order of dismissal termination.
I've not been able
Not new decisions, old decisions, these are been settled.
But nonetheless, Your Lordship, the thing is,
You bring those decisions that will help you.
Your Lordship, the thing is, the petitioner, he has been actually confined to his quarters. He has not been allowed to go on leave also. That is the problem. Even now, the district proceedings have started, charge memo has been issued. Even
What
now,
is the stage of the proceeding?
now written statement of defense has been.
When was the charge sheet submitted?
Charge sheet was issued, Your Lordship. Tenth of March, Your Lordship. 10th of March. So the thing is, when they are treating this suspension as a whole punishment kind of, and
Mr. Mehdi, what you No, we are not on the merits of the allegation. We are not on the merits of the allegation. We are on the point of suspension. Again, we are on the allegation. It may be corruption, it may be murder, it can be rape. We are not on that now. We are on the suspension. Hmm. Fourth. Fourth. Forwarding is fourth. No, that is the question. When does the suspension take effect from?
Yes, so far as we have
Page.
the case is under 114. 114 is third and case 115 is paragraph 4. Okay.
Paragraph 5.
Paragraph 4.
4. With regard to
That 115.
Hmm.
They all, uh,
you have filed two affidavit in opposition.
that is the affidavit matter.
You are referring to the affidavit or affidavit in opposition?
Affidavit matter 114.
114, yes. Paragraph 4.
Paragraph 4.
Yes, that all do. That all do.
Yes, sir.
Yes, please read.
That although the suspension order of the petitioner was issued by order that is 1/11/2020, but same was handed over to the petitioner on 7/11/2020. As the suspension order will come into effect from 7/11/2023. The 7 from
The Bora come prepared Monday. Directly on this point. Huh? Tuesday.
from 14
Then Tuesday 16th. When do you want? 16th, yes, can have. 6th or 16th.
If you have 28, then because motion day you are
Whenever you say. We don't want to delay this.
that's
A
what
very small point.
very small.
There's nothing to be decided. It's already been decided. 2-0. Yes.
And also, your lordship, I just like to place one particular OM of the DOP case as to when this suspension order takes into effect.
Where
That's in my rejoinder. Page number 6 of my rejoinder.
Inter
Chapter 1.
return page 6.
Internal page
12 July.
12 July 2007.
Hmm.
That is after the amendment of Rule 7, Sub-Rule
Hmm.
7.6. Paragraph number 4 here.
Hmm.
In deemed suspension, the sub-rule 2, the date of order of suspension may be much later than the deemed date of suspension. With a view to making these provisions explicit, sub-rule 6 of the aforesaid sub-rule 10, Rule 10, has now been amended to constitute the word 90 days from the date of order of suspension occurring therein, within 90 days from the effective date of suspension. Consequent upon this amendment, it would henceforth be necessary to specifically indicate in the order of suspension the effective date of suspension, which in my case is immediate effect. My contention is based on this particular OM only. their status specific that it is with immediate effect. And I may be handed over later on because I will stationed somewhere else in Shillong, and the Director General Delhi is in the Director General Porters in Delhi. That will take some time.
Where was the suspension order again?
Page 104. Second paragraph. Now, therefore, next. One day also, the Lordship that talks to this that item.
Is not written. 20. You take this back. You can hand it over later. Savora? You can hand this over later. On request this on 14th, 20th, 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 please, for admission. You're not, have not recorded anybody's name. Who's 7? You've got nothing to do. Second case for
Second case, I am telling the suspension order 111, the original suspension order, because it was colored with modified. For the time being, Your Lordship, I am only considering.
no, if you are reinstated, then where is the scope of challenge?
The original suspension order would remain. I have in the first petition, item number 13, I have challenged the 3-2 extension of the review order. There, the original would say that the review will go. This allowed, item number 13. So review extension will go.
If the review goes, how can the original be?
Lordship, that is the similar actually order. I have actually
There's no requirement, you're misconceived. The original order of suspension stays alive only because of a review. After 90 days, if charge sheet is not submitted in the meantime, suspension goes. We are only deciding on the point of on the date from which it is to be reckoned. If we hold in your favor, then if the review goes, the original suspension will go.
Very well.
UPSC, do you have any role?
Promotion. Was kept in
Slip cover. No, even if we interfere with the suspension order, there will be no effect to the DP. We are not touching anything on the veracity of the allegations.
We drew. I challenge
For
DP.
DP, that's okay. DP, you go ahead. DP, you are not saying anything. No observation of this court will be affected to the DP. That's why, and you, if you interfere, we will also give you liberty to post him somewhere else, so that the DP can be held in a fair and transparent manner.
Any non-sensitive code.
He can be posted in a non-sensitive post. We have interfered in a many suspension order on technical grounds, giving the liberty to post him in a non-sensitive post to facilitate you, the authorities, to go ahead with the DP.
And Your Lordship, this whole alleged irregularity happened when I was posted in NHI, not deputation. Now I have come back to Porter's office. Where can I? I cannot interfere.
No, that is on the sphere of the DP, the realm of DP. For suspension, those are not material.
I live.
Which by? Yeah, for a second,
The petitioner was retired from service on 31/12/2017, but till today, the executive engineer responsible for has not forwarded the pension paper to the AG office, as a result of which pay fixation for benefit.
What is the petition about?
My lord, it is my responsibility only limited there, my lord.
No, what is the repetition about?
Repetition, my lord, we have this second repetition I have challenged for the ex parte inquiry. That the first WPC case has been already disposed of on 12/6/2017, and in the state WPC case, my lord, I am the petitioner. I have been deprived from my legitimate right to receive my for last 11 years arrear salaries. Even my service was utilized by the government, and I was not paid the salary, and ultimately I am compelled to. And also, departmental inquiry was started in 2009. That was not completed. And
So
that's
what is the stage of the departmental proceeding?
the departmental inquiry was started only for the unauthorized leave.
What is the stage?
Huh?
What is the stage?
Of 14/8/2009.
What is the stage of the
That
proceeding?
that's why, in compliance with the Honorable High Court first order, they could not complete the department within outer limit of 3 months because he is going to be retired on 31st December 2017. After about 1 year, after filing a contempt case, they have suddenly issued a letter in 2018, and then with an ex parte inquiry report, that on which it was prepared, that was also nowhere mentioned. It has been decided. Contempt case also disposed of, and ultimately, my lord, in order to get relief from the contempt proceeding, they have sanctioned a nominal amount of rupees 7 lakh. And that 7 lakhs, out of 7 lakhs, again 51,000 was deducted. And that as per expert inquiry report, that amount has been calculated. And 51,000 was deducted. Then my lord, contempt case was disposed of with and no provisional pension was given for last 5 years. And ultimately, contempt case was disposed of with a clear direction to the respondent authority to release the provision immediately from September 2022. Actually, I am entirely looking for 2018. Anyway, I have accepted, my lord, the provisional pension. Now, regarding 51,000, they remained silent. They could not immediately to release the amount. Then I have submitted representation with the certified copy of the order. Now they have stated that they have altered and a separate contempt case we are going to file. Now, in this case, my lord, my very interesting point is, my lord, that the respondent number 4 has not issued, not served the, not forwarded the pension papers to the respondent number 6. About 6 years have been already done. SGOP has asked me. I have not received the pension papers. So, Lord, kindly see. I want to see my IIP. But annexer 1, my lord, page 6. That is the executive. Page 10.
But your challenge to the inquiry report, that is still pending.
Inquiry report, but the inquiry report is, my lord, not pending. Inquiry report.
Your challenge
Yes.
made to the inquiry report
Yes.
in the connected petition is still pending.
This WPC case is pending, my lord.
Pending.
Pending.
If that is pending, how can you say that the pension is to be released?
No,
That involves a huge amount of 7,29,000.
At least, my lord, the pension paper, as per their letter, immediately I have issued this.
Now there is an order for recovery from you. In view of the order, unless that order is set aside by this court,
But
in
there
the
is
writ petition,
no, my lord, no recovery order. My lord, no recovery order.
what is the outcome of the inquiry? What is the outcome of the inquiry? Let us see. Which you are challenging in the writ petition.
Actually, I am coming for this outcome the inquiry report, my lord.
Yes, let us see the inquiry report.
Inquiry, it's the main case, my lord, annexer 29.
Page
Page 262. 262 to 270.
After your comments were sought for against the inquiry report, is any action taken?
But, against this, as soon as we have received this uh, report, we are also asked to submit our so-called reply.
Yes.
My lord, that is also another letter dated 25/5 to 19 by the Assembly to Minister, expert inquiry report.
Thereafter, what has happened?
Uh,
After your reply,
my lord, regarding this case, the matter may kindly be heard in detail after, because I am actually coming for the IIP.
no, we are not getting the matter. You just, what is the stage? What is the stage of the proceeding?
In first WPC case, my lord, these are discussed. I want to draw.
No, what is the stage of the proceeding?
Yes,
Just,
yes, regarding, I'm coming.
Mr. Das, what is the stage of the proceeding?
So-called notice, allotment.
After the inquiry was done, there was a report. His views were taken. Huh?
My lord,
What do you have to go through it?
One amendment has been sanctioned, Annexure 40.
Huh?
Annexure 40. After this inquiry report, as per this inquiry report, they have released and they have sanctioned rupees 7,29,000. Thus, the area base 300. Base 300. We have submitted reply also, my lord.
After the reply, what had happened? Any decision taken? Your reply we have seen at page 277. 277 is your reply to the expert report.
So 270. Actually, we have
277.
expert inquiry.
Thereafter, what has happened?
We have yes, so-called reply on 20. That's called judgment. Oh, sorry. Yeah, okay. Expert 32. This method, based on which expert report was prepared, there is no mention. The Honorable Court has made an inquiry to submit their record. When you have prepared, they fail to submit it. It's about the expert
We are asking a very pertinent, simple question. What is the stage of the inquiry? Stage of the proceeding after the inquiry report? Your views were taken, you filed your reply. Thereafter, what has happened?
Final thereafter, as per since contempt case was pending, they have released this amount and informed the Honorable Court, and out of that 51% deducted. Then I am directed to
That you have already stated. We are not on that.
nothing was started by me. Further, no investigation was done. Only
Mr. Das, who can answer? Who can answer this? We know you want to know the stage of the disciplinary proceeding. What amount has been paid? We are not on that. If you say the disciplinary proceeding is on, or if it is culminated in some order, close the order. We'll have it on Monday next. Monday. Okay, whenever you say. Oh, no problem. Art Priya Sharma. Mr. Sharma, before we pass any directions, we have to be apprised what has happened to the disciplinary proceeding. If the proceeding has culminated in some penalty order, how can we?
No penalty.
We are asking you. You are not being able to answer.
Nothing has been done. Only this, they have ended this, and then we have prepared
Priya
it.
Sharma.
Finance department maybe.
Finance department.
The finance department inadvertently.
IA has been filed.
I have.
IA
Yes. I have
for imprisonment. Huh?
only two prayers. Of the
These are separate prayers, Mr. Sharma. How can you file one IA? One IA can be for one cause of action. Imprisonment is different thing. And pension is not for the finance department, some other department. if finance department was to be given some instructions, directions, then also probably one IA would have accepted one eye. Finance anybody served or not? IA served. Served. Yes, hard to serve. Yes. You have not served as a finance department. Name shown or not? Yes, you heard. They have training council. This IA has been filed.
I'll furnish copy.
Mr. Talia, there is an application for implement of finance department. Copy was not served upon. Implement is not a difficult thing, but we'd like to have your views. Normally, we don't say no to an implement application. But Mr. Sharma has some difficulties in the coming few days. We'll have it immediately on the reopening. In the meantime, let a copy be served upon. This IA has been filed with two prayers. The first with regard to forwarding original pension papers of the petitioner, and the second to implement the finance department as a necessary part. Filing one IA with two distinct and independent prayers may not be the right course of action. So be that as it may, since it appears, be that as it may, even treating this IA for consideration of the second prayer for improvement, it appears that the Standing Council of Finance Department was not served. Copies of Sarah. Sri Sharma has undertaken to serve a copy to Sri H. Aliha, who is present in the court. H. Aliha, Standing Council of Finance Department, who is present in the court. On the prayer of Mr. Sharma, to Learned Council for the applicant. Please, this matter. Today, when do you want? When? After
vacation, after 19th.
Tell us the date.
19th July.
List this case immediately after the summer.
After 19th.
List this case immediately after the summer vacation. Yes.
Yeah, please. In this petition, I am the petitioner, Lordship. Respondent authority apparently not enlisted by name in the senior gradation list. Lord. They have filed position in affidavit. My humble prayer before you, Lord, to file rejoinder. It interim may be continued, Lordship.
It's an interim order.
Yes, Lord.
What do you say? When did you file your affidavit? This court has been informed that the Panchayat and Rural Development Department has filed an affidavit in opposition, which, however, is not tagged with the record. Your name?
B. Kaklari, Lord.
Sri B. Kaklari, counsel for the petition. However, submit that he would like to file a rejoinder petition
Rejoinder, Lord.
for which he prays for and is granted 3 weeks time.
Lord.
3 weeks time. Put the para. List of the 3 weeks. Para. Interim order passed earlier. To continue till the next year.
Give a blessing.
Para. Registry to take the affidavit to the case record. 30th of March. March. Yes, next.
Oblige, Lord.
May be the my lord, the petitioner here in the year, my lord, 1996, after completion of a diploma in engineering, joined as an electrician in the PWD annexure 2 page 30. Thereafter, my lord, by taking study leave, he completed her BE in the electrical engineering. Electricians, they don't have any service route in the PWD. My lord, so after she completed her BE as an electrical engineer in 2007, from then onwards, she is still working as electrician, but with no service. Thereafter, my lord, he approached this court, court directed her to file a representation and the representation to be considered. Then, my lord, in between, there was in 2015, there was a draft service rule as a technician draft service rule by the federal, where they have stated that in 7 years, as after holding the post of electrical engineering, if you continue for 7 years, you'll be considered as junior. So, my lord, now on the basis of that draft service rule, I find a reason there was an interim order that because there was a vacancy in the post of junior engineer, one post of junior engineer was kept reserved for. It was in the February of 2022. Well, thereafter, they filed an affidavit, government filed an affidavit stating there in that your representation has been disposed of on a consideration that it was filed in 22, the affidavit. In 2021, their representation was disposed of, stating that when the draft service rule will be finalized, you will be considered and you will be given promotion. And because there is no service rule in this, and you are a cadre post, you cannot be considered for post. Now, after that, they file an affidavit and say, because from 15 to 21, the draft service rule was. Now that service rule has become obsolete. We are cancelling it, and it's a stop for your because from 15 to 21, the whole life to get any promotion. Not even a single promotion you will get, and you are out. That was their consideration. So I say this is in violation of Article 6.
What is your age?
Now, my lord, I will be ending my career within 1 or 2 years. I will be.
Yeah.
My lord, so, my lord, such a long period, my lord. And my lord, I got a direct judgment from the Supreme Court. I stated, even the my lord, superior officers have recommended my name that he is a very good worker. He is working as taking the charge of working as an electrician, but performing the duty of an engineer. That way, my lord, all my documents I have annexed. The court also held earlier that your representation should be disposed of, and my lord, neither virtually if there is no service, so they are not giving a pay scale also, like a virtually lump sum amount I am getting. Virtually, my lord, here in my case now from 1996, today is 23, working as an electrician. In 2007, I am taking a study leave. I passed my engineering.
After 2007, why did you take part in the direct recruitment for assistant engineer? Number one, that's the first question. Number two, you were not a diploma holder. Were you a diploma holder?
My lord, when I joined, my lord, in 1996, I appointed as a regular technician, electrician.
What was the qualification you had?
My lord, during in the office, my lord, it was not written there.
You were not a diploma holder.
My lord, in my petition, I have stated that your lordship just keep some. I have my lord, diploma course in electric engineering in 1990.
You are a diploma holder. And you have not shown this part of the statute which gives there is a percentage in the first cadre of engineering, namely assistant engineer. There is a ratio between a direct recruit.
Promotion for assistant engineer, sub plus 1. Possess qualification of diploma in engineering as recognized by the government. Has rendered 8 years of
8 years.
minimum service as junior engineer on the 1st January of the year of promotion.
But you were not serving as a junior engineer.
No, my lord. I was working as an electrician. That was our next cadre. So this is assistant engineer. From junior engineer, I could go to assistant. My lord, in many cases in this
Why
department,
didn't you apply for junior engineering?
because, my lord, in other similar cases, they have allowed the electrician to retire as executive engineer.
You apply for junior engineering?
Or some names I have given, my lord, like my lord, Bhavesh Chandra Deka, Sudhak Hussain Sharma, Motin Chaudhary, promoted up to the rank of executive engineer.
No, the promotion has to be in terms of the Assam engineering service rule. Assam engineering periodic service. Now here there are two avenues. If you are a diploma holder joining as a junior engineer, then also after serving for a particular length of time
As a junior engineer,
then you get inducted in the SHJ, in the cadre of the superior service of engineering, and there is a particular percentage for diploma holders who are junior engineer and a engineering graduate who directly enters into a direct recruit. Now here your case is a slightly different one. You say after attaining the diploma, you joined as an electrician, which is not a junior engineer.
not a junior.
Now, when you were a diploma holder, you had option later on also to be appointed or to at least compete for the post of junior engineer, which you have not done. After attaining your graduation in engineering, BE, your avenues to be appointed as an assistant engineer are also open. Which you did, no, assistant engineer.
Because
After BE,
BE.
after BE, assistant engineer. There is no question of junior, which you have not done. Now, you have not taken advantage of your qualification.
My only
Now
case,
there is no ladder from of
my
promotion.
only case, my lord, when there was a draft service, and they have considered my case on the basis of a draft service, saying that when it will be finalized, I will be given promotion on the basis of a draft service. Suddenly they say that it's optional. Can there be a stagnation for a particular lady without a promotion? Is it not in violation of Article?
No, you entered into the post knowing fully well that there is no promotional letter.
My lord, but they have given promotion to few persons from electrician to executive engineer. From electrician, I have given the name.
We have to see under what conditions.
My lord, because they were working, they were performing last day, they were given the,
There has to be some other reason.
because
Mr. Dhar, Mr. Dhar, what is he saying something? Is it correct? And we want to know the background. What was her? What was her qualification? Diploma holder. At
during
that time.
91, I passed my diploma.
But she did not join as a junior engineer.
My lord, that there are also very provision, promote and electrician, etc. Then my lord, still during that period of time, he had this service. My lord, because the amalgamation of this railway and building, now it's from one department. So the earlier chapter, that is the two of the finance department. Department by us go for a new service. So now this is the condition. My lord will there is the last one.
How?
My lord, we have already. My lord, for this. Thereafter, the party of very important. Only that was
whether some provision can be made in the proposed service rule to provide for promotional avenues for electricians.
What I don't, what
But considering the long period of service is rendering, almost 3 decades, and having the qualification, can't you make an exception? You have the powers to relax also.
relax, yes, relaxation is there. What are the relaxation rule 28?
28 is there.
That is what I said. There is
He's retiring.
no, he's 52. No, my lord, I have 4 years to read. My lord, I go by the affidavit first to out 50.
At least 7 years.
7 years is there. If I go by the affidavit, my lord, only my lord, equal also purpose me to read one judgment, my lord. There are 22.
Page, what pictures?
My lord, I am discussing the judge.
Tell us name.
So, it is 2008, 5 ASCC, page 100.
2008. Name,
Where, my lord,
name,
my lord, name is Food Corporation of India and others versus Purusattundan Bansal and others.
what has been said?
My lord, absence of judicial intervention when there is absence of avenues for, my lord, they have stated there, my lord, that, my lord, put and direct creation of avenues for promotion in there. Put and direct. That is their, my lord, basic thing. That, my lord, and
Where's the
another judgment, my lord, I will just where it has stated in paragraph 22, my lord. My lord, may I read it, my lord?
same judgment?
No, my lord, judgment is, sorry. Judgment is, my lord. 2011 NSCC page 401. 11 NSCC page 401. 2001 NSCC page 401. Para 22. May I read it? Notwithstanding our aforesaid conclusion, it would be interest of the administration to have a channel of promotion for every service so as to avoid stagnation at a particular level. Subject, however, to the condition that the incumbent of a service are otherwise qualified to shoulder the responsibilities of the higher promotional post. The appropriate authority of the government should therefore bear this in mind and consider the feasibility and desirability of continuing the supernumerary post already created in the boiler and the practice department on a permanent basis, so that the employees of the lower echelon in the state department have a promotional channel, or to make a suitable promotional avenues to list up to some level, so that there would not be any discontentment among the employees of the department. So, Malak, here, Malak, I have qualified everything is there. If it's a superior authority, I have annexed all the documents. They have said that he is qualified, he is working electrician in the name of electrician, performing the duties of an engineer. And now, my lord, suddenly they say, my lord, that because the building and the other roads are joining together, this drug service tool is obsolete. And on the basis of that drug service tool, there was a one post was kept. The 3 posts were flying jacket of the junior engineer. And now, my lord, at least now, because the representation has been disposed of, in the annexure they have stated. They have stated in the annexure that on approval of the Assam technician established service role, if Anita Shaika is found eligible for promotion to the next higher rank, her promotion may be given effect subject to availability of vacancy and fulfillment of relevant rules. That was on 23rd June 2020. 23rd June 2020, and the job service tool started in 2015. So 25 years it was there. They were not doing anything. Suddenly in 22, they filed an affidavit and they say, my lord, that the opined by the draft Assam technician service tool has become obsolete and prepare a new service.
Now both the departments have amalgamated.
But we have electrician department. We are electrician department.
How do you reconcile? How do you, he has made a statement that similarly situated persons
Well, the names
have
I
been,
have given.
what is your take on that? If you could give the benefits of promotion to somebody who was similarly placed, consider her case. You have powers to relax. We want your views on that. Where is the statement, page, paragraph?
My lord, that was I found in the synopsis, my lord, but particular paragraph was not there.
No, no. Your contention that uh, 4 persons have been given the benefit.
I've given the name. Regarding my lord, names were given in that particular synopsis, but paragraph, my lord, I found.
At least you got the door. You get the names from the synopsis. You
Given the name, lord.
take instruction. Third PK Roy Chaudhary, Learned Counsel for the petition. Also heard the Ardhur, Understanding Counsel, PWD. The petitioner's case is that he has been serving the Department of Public Works continuously year 1996 as an electrician. The petitioner claims to have subsequently attained the procured BE degree and is therefore eligible posted in the as an assistant engineer. So it is also submitted that prior to our appointment as electrician, the petitioner had obtained her diploma in engineering.
In 1991.
Sarah. Roy Chaudhary, the Learned Counsel, has also submitted that certain similarly situated persons have been given the benefit of such promotion. Also, recourse to section 28 of the recourse to section rule 28 of the Assam Engineering within bracket PWD bracket close service rule 1978 has also been taken. Also, para 3 third training council of the department, however, submit that the claim of the petition is not sustainable, and the department has also filed an opinion of which. However, the training council submits that he does not have the instruction with regard to the government made with regard to the submission that certain similarly situated persons have been given the benefit of promotion, whose name also appeared in the synopsis.
Yes, yes.
In the interest of justice, list after 10 days. No, if we get a positive feedback with regard to the persons who were given the benefit, then we can pass an order in a very positive manner in the lines of such consideration. Similarly situated persons This synopsis, let this matter be listed after 2 weeks or 10 days. After 10 days, whenever read her the out the standing
Your lordship may fix it
to
upon
obtain the instruction to obtain the instruction. List on
23rd, my lord. No, my lord, 23rd, 19.
21st.
20. With the support of my friend, I can get some. He can only.
No, at times matters are unfortunate 3 decades or more. But you are also taking a chance. You are afraid to compete. At least if you had joined as a diploma, as a junior engineer, then also you're
no problem.
no problem.
This matter needs to be tagged with WPC number 0139 of 202, and thereafter both the matters
Connected.
should be tagged.
Yes.
My lord,
In the second one, secretary is a party.
I'll just point out the fact.
No.
No, I'm a secretary of a society. I
No,
was placed on a suspension.
since we are having it on another day, Sri as Bonik happened, there is another repetition being WPC
4139
of
202.
4139 which is required to be decided together. Para Sri Talukdar, the understanding concept, cooperation department does not object to the state. Para, list after a week, along with list after 2 weeks, along with
Matter, my lord. His focus notice was to favor of me, my in a on charges the prevention of production. Thereafter, my lord, an inquiry was held
Lupus was issued by whom?
by the chief and the president studying the case. Statement of time was
DGP as a disciplinary authority. Okay.
Person there to my lord, I have submitted my written statement, my lord, inquiry was held, and person to that inquiry, my lord, at page 38, the discipline authority has passed an order and dropped the charges against me, my lord. The Secretary to the Government of Assam, Home Department, page 38.
Mm.
My lord, five lines from the
Yes,
from my lord. Thereafter, my lord, another focus notice has been issued, my lord, on same set of terms. Because of this focus notice, my lord, I have not been considered for further promotion, my lord. Whereas my promotion, like my junior second promotion. Kindly period the last order, my lord. The last occasion, only they have submitted an affidavit has already been filed. Probably this is for waiting, my lord.
Madam, we may grant you, or that's a different matter. But the point which is raising is a pure point of law. If you are disputing on fact that the inquiry report exoneration was not there or it was dropped, then the matter may be different. But if an inquiry has ended, culminated by a report which is in favor of the petition, then the law is laid down, settled. Even if you want to proceed, you can proceed, but that's a different stream altogether. You cannot again reopen the entire thing and go for a fresh inquiry. That is the settled position of law.
5 was him and the second
Logical and means the report was in his favor. Drop.
then second one 8 were 20 and the report is that in this so for the uh, the the inquiry Rule 9 of the Assam Services Code is not what power of the Secretary of the Court
What are you reading?
said after inquiry was
Where was it? Okay.
provided into and taken into its positive and also the so-called notice is that not but it charges that are either at
Okay, you want to contend that the charges are different. Let us see, have a look. Prime Minister. Where is the first one?
First one is, my lord, will find a case report.
because what I was
What has been recorded in the new proposed notice, my lord, it has already been recorded in the inquiry report, my lord. It has already been considered. After considering all these things,
24. Let us see.
yes, my lord. That's
When-
page 24. This is the first.
Okay.
May I read, my lord? Second paragraph. That while you were posted as Deputy Superintendent of Police, Dhubri, a case by Dhubri PS case number so and so under Prevention of the Corruption Act was registered against the Abu Anis Akhtab Momin Principal, Hadurhat Dharamsala HS School, and the case was endorsed to you for investigation. Accordingly, the Abu Anis Ahmed Momin, accused of the case, was arrested and forwarded to judicial custody on 23/5/2018. During investigation of the case, Sri Ariful Islam, brother of Sri Abu Anis Akhtab Momin, accused, appeared before you and requested to send case diary of the case to the Honorable Court in the time for bail matter. You refused to do the same. Instead, you demanded ₹1 lakh. Case as bribe from Ariful Islam, and then Sri Ariful Islam agreed to pay the demanded amount. Later on, Sri Ariful Islam paid ₹60,000 only by cash and handed over to you at your office chamber. Thereafter, as per your directions, Sri Ariful Islam handed over ₹25,000 to your residential order, namely Sri Krishnana, on 4/6/2018, which was also video recorded by Sri Ariful Islam through his mobile phone. You also demanded money from Muhammad Abu Anis Akhtar Momin after his release of this. In this regard, the main application against me, my lord. And my lord will find the report of the inquiry, my lord, at page 29. And finally, my lord, turn to page 37.
Hmm.
Page 37. This is the last paragraph. Made it.
Hmm.
After careful examination of all the statements of
But
witnesses,
here, apart from 37, this is the inquiry report.
this is the inquiry report.
You have a 38 also. The proceeding was
Thir-
dropped.
38. Based on this inquiry report, my lord, may I read this the last paragraph? It's very relevant because
No,
it is recorded in the new proposed notice. It
It
has
was-
already been considered.
It was dropped.
It was dropped. Page 37, the last paragraph. Very relevant.
No, that you 37 you need not even rely. 38 is disciplinary.
38, yes, it
They have
was
dropped the proceeding.
Yes.
Thereafter,
Thereafter,
new
my lord, again, proposed notice was issued, my lord, at page 39, which is under challenge.
Yes.
Said, my lord, while you were posted as Deputy Superintendent of Police, Dhubri, a case by Dhubri PS, case number so and so under Prevention of Corruption Act 1988 was registered against the Abu Anisa. Same,
Please keep on reading.
and the case was endorsed to you for investigation of the case. During investigation of the case, one Sri Ariful Islam, son of late Khairul Hassan of village Toto, 4000 PS, that is submitted FIR on 24/7/2018 Dhubri PS against you, alleging that you demanded money from him, and a case was registered by Dhubri PS case number 1043 of the 2018 under Section 7 of Prevention of Corruption Act 1988. In connection with this, a departmental proceeding was drawn up against you on dated 5/9/2018. The state departmental proceeding was disposed of on 6/8/2022. However, the inquiry officer in his inquiry report submitted right dated 31/8/21 mentioned that in your defense statement,
you admitted to have received an envelope, but you stated that it contained a CD. Further, during examination by inquiry authority, you stated that CD was relevant to case number 654/18 under section 341, 352, 323 IPC, read with section 7 PC Act, of which you were the investigating officer. Also, during the examination, you stated that you did not report about the receipt of CD in the case diary of Dhubri PS case number 654 of 2018. This last part, my lord, is already mentioned in the inquiry report at page 37. After considering this, my lord, my CD was dropped on order of page 37, my lord. Kindly have a look at page 37. Next, for being a member of disciplinary force, responsible police officer, your above act shows as gross misconduct, indisciplined conduct, and dereliction of duty. Hence, you charge with gross misconduct, indisciplined conduct, and dereliction duty. You should submit to written substitution. Page 37.
Yes.
Last paragraph. After careful examination of all the statements of witnesses, it is proved that Sri Bhaskar Uza, this is the petitioner, the DSP headquarters Dhubri had received an envelope from Sri Ariful Islam through his residential orderly Sri Krishnanath. In his defense statement, Sri Bhaskar Uza admitted to have received an envelope but stated that it contained a CD. Further, during examination by the inquiry authority, he stated that the CD was relevant to case number 654/18 under section 341, 352, 323 IPC, read with section 7 of PC Act, of which he was the investigating officer. Also, during examination, he stated that he did not report about the receipt of CD to his supervisory officers and neither sees nor mention about it. The complexes in the case diary of Dhubri PS case number 654/2018 under the circumstances above, the charges of gross misconduct, undisciplined conduct, and dereliction of duty on the part of the Sri Bhaskar Uza, the then DSP headquarters Dhubri, has been proved. After this inquiry report, my lord, it was considered, and at page 38, the inquiry was, the disciplinary proceeding was dropped. Thereafter, again, this focus notice has been issued, my lord, and this fact has already been stated in the inquiry report. The disciplinary authority has already considered this, all this fact.
Where is the affidavit of it? You want to file it? We grant a small short time. But this case is on, I think, how much higher footing. Even if the inquiry report, uh, even if the disciplinary proceeding had ordered for a fresh inquiry, then also we interfere. But here, inquiry was against you, which was not accepted by the disciplinary authority. Proceedings dropped. Then the same disciplinary authority, can they initiate another?
No, my lord, as per rule 9, they cannot. That is judgment passed by the Honorable Supreme Court, my lord. The same set of charges, my lord, is not empowered.
That cannot be. Madam. It's based on the same allegation. Now, in the inquiry, it was held against him, but the disciplinary authority took a call and it was dropped. Nine. Yes. Yes.
Being a member of
That we have seen. These were all there. This was taken care of by the inquiry officer in the first round. But till the disciplinary authority, you have taken a call that we are not proceeding because you have examined the statement of the witnesses and none of them are against the petition. We grant for a short time. Is there an interim order?
Yes, my lord. Let it stay on this basis.
Hard, yeah, RM Tech. Senate Council for the petition to submit that the disciplinary proceeding which was initiated against him by the so-called notice dated 5/9/2018 had culminated in an order dated 6/8/2020 by the disciplinary authority, whereby the proceeding was dropped against the petition. Whereas, however, by the impute order dated 8/12/2022, another proceeding has been initiated against the petitioner. On the same set of charges. Sarah, MSc Taluk and State Council, however, submit that the allegations are a bit different. The further submit that the affidavit in opposition is almost ready and would be filed shortly. Sarah, list after 2 weeks, 10 days, list after 10 days. Sarah, interim order passed early to continue to the next set of Madam, you tell us the date. Today,
Second,
today is
it is 8 Monday, 22nd.
yes, 2 weeks easily taken.
22nd,
We'll have it 21st.
21st. And deeply obliged.
Yes, I
ILO.
for
Repeating note.
Number 6. But so he is the official liquidator of the system paper control. Now that is a good development here.
on the last occasion, court has asked you to do something to examine whether the liquidator under the law retains the power for reinstatement.
But now what the company liquidity receipt now only receive the amount receipt. Now they
Okay, we'll allow this. Here for justice and commerce. Havildar for CCC. Your Malakar.
Yes.
Third, three, E. Malakar. Senate Council for the applicant petitioner, who by means of this application has prayed for improvement of the official liquidator who has been appointed after liquidation, after the Hindustan Paper Corporation Limited has gone on liquidation. The subject matter, the writ petition, the writ petition was initially filed against an order of removal. Removal or what? Removal of the petitioner from service by the erstwhile Hindustan Paper Corporation, which is now under the control of the liquidator. Also heard your name and Kalita. And Kalita Council representative they are right appearing on instruction of the A. Kalita, Planning Council, Industries and Commerce Department, whereas the Arbiter Council has appeared on instruction of MSRDV. This is court of after hearing of this court is of the opinion that the treatment may be allowed in the interest of the court. According to the so and so inside our page पूरा लिखिए is implemented as the number 6 in WP 803 of 2013 put the registry to make correction, make addition, correction, to insert the name of the newly implemented response number 6, the array of parties, full stop. ISS is full stop. The WPC, right? In view of the order passed today in IA 1790. One seven nine zero 50.
1705 is the
In your prayer, what have you written? In your prayer, in the prayer, what have you written of the IA 1705 of 2020? Keep it. Put it. In view of the order passed today in IA 1790 of 2022, whereby implement of a new income that implement of the liquidation has been allowed, comma, the registry to make necessary insertion of the name of the newly implemented respondent as respondent. Petitioner is also required to take steps by registered post upon the newly implemented respondent. That notice, that service, that notice be issued by registered post step 22 days. Step 8 given notice for that. List of the four along with the report. Here it is what it is.
I can remove it.
Again?
Remove it.
Remove it. Hmm? Which department? Public work.
Malota.
Removal after an inquiry.
After
Charges.
Madam.
What were the charges?
charges, the 8 number charges are there two departments initiated. Some charges are which merged with the third purpose. First purpose was listed by the election level there in our merged with the last. So third it was initiated. The findings of the second method that was either rejected, that was not against considered the time and
Affidavit file.
affidavit file.
How much? How much amount?
That was not true. That was not report.
Okay, you go to the record, we'll have it whenever you. But this is a removal matter, 19 matter, will give preference. Tell us when. Not after vacation.
Report.
You have the record, you have to go through.
Record system,
In the weekend, don't go for vacation in the weekend. Go through the record.
2005.
Don't go for vacation. Go through the record. We'll have it on 20th to 0.
Witness
No, to,
hearing them.
no, no. We'll have it on a hearing day, 20th June 20.
20.
The Tuesday.
Tuesday.
Third PM के शर्मा for the petition. The other understanding concept. Handloom and Textile Department submit that record, that original record have been obtained. Full stop. He, however, prays for some time to go through the same. After considering the subject matter, which is removal from service after a disciplinary proceeding, let the matter be listed for consideration again, and again on 20th of 26.
Obliged.